Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Morris Silberman, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning, everyone, and welcome to the Second District Court of Appeals remote oral argument session. I am joined today by Judges Atkinson and Smith, and we are pleased to be with you today. We have 5 cases on the oral argument docket. I will call those cases in the order that they are scheduled. There will be a brief pause when a case is called to allow the participants into the virtual courtroom. After each case is completed, the participants will need to click their leave button. And of course, they may continue to watch online if they so choose. As a reminder for everyone, each side has 20 minutes for argument. If you are the appellant, please let me know if you would like to reserve up to 5 minutes of time for rebuttal. I will let you know when you get to that point of the argument so that you can save it for rebuttal or move forward. Make certain to unmute your microphone when you are recorded to present your case. And with that, we are ready to proceed. And if you will give me a moment, I will get the docket back up on my screen to make certain that we go in the right order. So the first case is, here we go, Nunez-Zinez versus State of Florida. Very good. And I see both counsel are present. So we are ready to begin with counsel for the appellant. Mr. Atkins, you may proceed.
Good morning, Your Honors. Wayne Atkins for the appellant. I will reserve 3 minutes for rebuttal.
Very good.
And this is a case that arises from an indirect contempt proceeding based on the failure to comply with a search warrant. We initially presented 3 issues in the initial brief. We ended up conceding one of the issues after reading the answer brief as to the jurisdiction of the court. So that now there's only 2 issues pending before the court. One is whether the underlying order that was compelling the disclosure of cell phone passcodes was void. And then the other issue is an issue of whether there was sufficient evidence of intent based on evidence of whether the order was translated for the appellant. So I'll start with the issue of the validity of the order. This is an issue that's been currently pending for the Supreme Court based on a conflict amongst the district courts. Oral argument was held before the Supreme Court in November. We don't have a decision yet. That obviously may impact what we do here today. Until then, I'll acknowledge we have to follow the Stahl decision from this district. However, I've offered a couple reasons in the brief as to why that might be a little factually distinct, which actually might help to bring some of the district courts a little more into harmony. So in Stahl, that case was a video voyeurism case where there was evidence that the defendant there was observed using the phone to conduct video voyeurism. So it was very targeted in that case. And then in the course of deciding that opinion, holding the compelled disclosure of the passcodes there was proper. Under Fifth Amendment, and whether it was a testimonial communication, it was the focus was on the knowledge of the passcodes themselves, because as part of this Fifth Amendment analysis, there's an exception to testimonial communications if it's a foregone conclusion that the state would sort of get that evidence, that they know the evidence is there, that the defendant is possession of it, that it's authentic, is I believe the 3-pronged standard. But it was a very targeted request there. And this court held that, well, there's evidence he knows the passcodes, so that's all we're concerned with, not the evidence they might ultimately get from the cell phone. But they actually included a footnote at the end that kind of acknowledged, like, yeah, this is very, even under the kind of a broader view of this doctrine, we think it's still safe. Since then, there have been other district courts that have focused more on the ultimate evidence to be uncovered. But if you look at the request,
Mr. Atkins, before you go to the other courts, let's address something in Stahl to this case, because we are bound to follow Stahl if indeed Stahl is applicable here. And so one of the things that Stahl says is to know whether providing the passcode implies testimony that is a foregone conclusion. The relevant question is whether the state has established that it knows with reasonable particularity that the passcode exists, is within the accused possession or control, and is authentic. And so if we were to apply that test to our case, aren't all of those elements met here? Because you have the accused's possession or control of the phone itself, and he was seen using the phone at the time that the detective saw him using the phone. And so, and I think it's also, as far as authenticity, basically the case discusses that, okay, once we punch the numbers in the code, punch the numbers in the phone, then obviously you know that it works if it unlocks the phone. So that would provide the authenticity element. So if you would answer that question.
Yes, obviously we are bound by the decision in Stahl, but to answer that question, I mean, yes, there's evidence of sort of all those elements. I don't know that it's conclusive and all that I can conceive of, although it's not in the record, how you can talk on a cell phone. I think you can answer without a passcode, but that's not something that was really developed factually. So it's possible there's still wiggle room there factually, but yes, there's at least evidence in all those points. I mean, it could be subject to a little debate around the edges, but I think so. But sort of looking at the requests there, because Stahl had a very targeted request of seeing this phone being used in the course of a crime where the phone was used to conduct the crime itself there. So I think what the other districts got a little hung up on is it wasn't as directly tied to the crime. It's sort of, state was generally seeking communications, kind of like what they're doing here. And they were hung up on, by providing the passcode, you're sort of authenticating a whole broad range of documents and communications. And that's how they distinguished sort of surrendering a key to a house from providing a passcode to a wall safe, I think is what the case is.
Right, but by necessarily providing the passcode doesn't mean that the defendant here is admitting to all of the contents. I mean, that would be subject later to a motion to suppress, right?
I mean, they're admitting that they know the password to the thing that has those contents. So in a sense, it's an admission of it. It's not, again, it's not like, I don't think it's a conclusive admission. Obviously that's subject to being further developed and challenged, but I think there is some admission where it is evidence of some knowledge of the contents of the phone, and it's authenticating sort of, I guess, the act of production. It's sort of authenticating a much broader category of things in the other cases than it is in, I think, Stahl.
But wasn't there, yes. But was it, I mean, and I know the caution is just to let the state go on a fishing expedition. But here you actually have some, I believe it's like AT&T records that they had some independent evidence of that would tie in the time periods in which the defendant here was on the phone, correct? With
yes, there are those records that do tie the phone to the defendant. So that's certainly evidence that the state presented and has. And yeah, I think the concern is sort of the fishing aspect, but it's a difference in Stahl. It's sort of like fishing with a line for a specific fish. In the other cases, it's sort of fishing with a net, casting a wide range of things, seeking more general communications as opposed to direct evidence of the crime that he knows on the phone. But obviously the Supreme Court's gonna weigh in and resolve this, hopefully soon, and that'll probably have a big impact on what we're doing today. Here, that argument wasn't really developed as much below. I think the state acknowledges in their answer brief that before the contempt proceedings, there wasn't really any opportunity to challenge it. And even at the hearing itself, the judge didn't really want to hear and get into evidence of whether the order itself was erroneous in any way. There's some objections to relevance that he sort of sustained on that ground. So this wasn't fully developed and fleshed out, and that itself kind of limiting, I think, us a little factually. And as for the state also raises an argument that a motion to suppress is sort of an adequate remedy for this. I don't believe that to be the case, because it's sort of, well, a couple issues there. One, it's sort of the cat out of the bag issue we run into in the context of these civil discovery requests and certiorari. And then also just the risk of being held in contempt of court is sort of itself almost recognized in some of those same cases as a form of irreparable harm. So it's hard to remedy an issue like this after the fact, even in the form of a motion to suppress. So that's kind of the issues I have as to the validity of the order itself. Unless there's other questions on that topic, I'll move on to the kind of second issue of the evidence of the intent. So the issue with intent is there's evidence in the record that this order, my client speaks Spanish. This order was translated by an officer who didn't testify into Spanish, but the officer who did testify didn't really speak Spanish, admitted he can't really confirm whether the order was read accurately. And sort of a fundamental element of a contempt violation is willfulness. I'm sorry, did someone speak? No, it's an issue of willfulness, and you can't be willfully in contempt if you don't know what you're being ordered to do. And so we think there's a failure in the elements there and a lack of competent substantial evidence on this point. I did cite to a couple cases, one from this court and then one from the 4th DCA that sort of recognized in the context of admitting translations that you don't need to necessarily have a certified translation, but there needs to be some safeguards to ensure there's accurate translations before they can be admitted into evidence. And I think that can be sort of applied by analogy here, where we just don't have competent substantial evidence that my client even understood what he was ordered to do at the time. And other than that,
and the cases on that point, I think you had Lopez and I think it was Mendez Martinez. Those cases there, a transcript was actually being admitted. Do you have any circumstances here? Any cases where the officer who was testifying was not the one who did the translation?
I couldn't find anything like that myself. Yeah, I recognize those cases they're not in the contempt context, but yeah, they're both trying to admit, I think, translations or transcripts, I believe, but I couldn't find anything quite like this. Where it's an officer, a non-testifying officer is one who did the translation. But those cases, I do recognize some sort of safeguards to using these transcripts where there needs to be some evidence of whether they're even accurately translated that can be subject to cross-examination. And where we don't have that at all here, we're just operating on, I guess, the testifying officer's assumption that his colleagues translated accurately. And that's not enough. That's not competent substantial evidence of the element of intent. But no, I have nothing exactly in kind of the context you just described.
Okay, and you would concede that that issue wasn't raised in your response to the motion to compel, or I guess it was to the order to show cause?
In the response to the order to show cause, I'd have to double check. I can't remember. I don't think so. I know it was definitely raised at the hearing, but for the response to the order to show cause, I'd have to confirm that. It probably wasn't fully fleshed out if it was raised at all. I don't think it was, but I'm struggling to remember that particular document off the top of my head right now. I know it was developed at the hearing, but that's it.
Mr. Atkinson, let me ask you, to take this issue to a broader context, would anytime there's a discussion between an officer on the scene and someone who speaks another language, where the officer on the scene speaks in the base language for the defendant, that particular officer must always come in and testify that he accurately told the defendant whatever it is that's at issue, he or she?
No, not always. It's in this context, it's because we're in a contempt proceeding. So knowledge of the order itself is a fundamental element So being
But
evidence.
you have testimony, it was translated, and I understand what your argument is, but your client did not testify. No evidence was presented challenging the adequacy of the information provided to him, was there?
No, he did not
And
testify.
I understand you're saying, well, it's a shifting of the burden of proof, but again, to take it to what I think is the next logical step is if a person makes a confession at the scene of a crime after giving Miranda warnings translated into the native language, then it seems like you're positing that there has to be some independent proof by someone at the trial or the suppression hearing that says the warnings were accurately, fully translated, and it appeared the defendant understood them, as opposed to a witness testifying. It seemed clear at the time that Officer A translated and the defendant responded appropriately to questions.
Understood. So it's very context specific there in the context of whether we're confirming the accuracy of Miranda warnings. That would, I guess, be raised in the context of a motion to suppress. And I think the burden's a little bit different there. But as for a confession itself, there's going to be probably, there's usually, I think, other evidence of a crime beyond the confession. But if you're relying on in a contempt proceeding, I think knowledge of the order itself and what it's required is kind of the central issue for the willfulness. And I think there, for the state's burden to prove willfulness in that context, it's a lot more problematic to rely on essentially the assumptions of the only witness who did testify that he asked it to be translated, and but he doesn't know if it was translated accurately and admitted he doesn't know. But I think those are a little bit different contexts than what we have here. An admission, yeah, obviously, if there's, I think in that point, if you're trying to suppress it, there might be a burden on the defendant to come forward and challenge and say it wasn't voluntary. But in the context of the state proving intent on a contempt charge, knowledge of the order, I think, yeah, there does need to be some evidence that it was accurately translated, but no, not for every conversation with the defendant ever or a witness ever. I think it's very context specific.
Very good. And you still have your a little bit more than 3 minutes if you have anything further you want to add.
Understood. Thank you.
Very good. Thank you very much. And I'm having a little bit of computer problems today, so you all forgive me. Ms. Heim.
Good morning, Your Honors and Counsel. May it please the court. My name is Allison Heim. I represent the state of Florida. As an initial matter, the merits of the underlying search warrant are not actually properly before this court for consideration. And to the extent the state's answer brief states otherwise, state steps back from that position. And instead, the narrow issue before this court only deals with sufficiency of the evidence of the finding of contempt. So that leaves just essentially, there was an order directing the defendant to do something, and then the defendant's intentional refusal to comply. So in this case, I don't think it's disputed that the search warrant itself directed the defendant to supply a passcode. So we have the order directing the defendant to do something. So the real issue is if there was an intentional refusal to comply. So counsel discussed a lot about what happened at the evidentiary hearing on this matter and the Spanish translation. However, before the parties even stepped into that particular hearing, the evidence of intent was already proven beyond a reasonable doubt. And that was done so in the appellant's written response to the court's order to show cause. In that order, he did not challenge the Spanish translation or indicate that he didn't understand or even wanted an attorney, nothing like that. Instead, he indicated that he had every right to refuse. That's on record page 11. He had every right to refuse compliance because he believed he had a constitutional right to do so. Then again, on page 20, he admitted intentionally refusing to comply, where it says the appellant believed he could refuse to provide the passcode to the cell phones because of his Fifth Amendment right and his Fourth Amendment right to challenge the validity of the search. He intended to exercise his constitutional rights. That can be taken as proof of intent based on this court's holding in the Hope v. State case. And in that case, it was very similar to this one, where the defendant was called to testify before a grand jury. He refused to testify. The court initiated contempt proceedings. And during the proceedings, the state offered attorney argument showing the intent. The defendant on appeal argued that that was not sufficient evidence because it was simply attorney argument and they were not sworn to testify. But this court found that in the defendant's written response, he acknowledged his refusal to testify and said he did so because of his constitutional rights. So it wasn't a contemptuous intent to disobey. It was coming from more of a constitutional standpoint. And this court held that that written response was enough to show the evidence of intent, and that any further evidence during the hearing would have been superfluous and just in excess of what was already proven. So we have that same issue here. The issue of intent was proven before the parties even entered into the evidentiary hearing. As I stated earlier, I don't believe that the constitutional arguments and the merits of the underlying warrant are properly before the court. And even if an order is erroneous, unconstitutional even, a defendant still has a duty to comply with that order until the order is modified or vacated or reversed on direct appeal. But it can't be collaterally attacked on an appeal of finding of contempt. We know that from the Jamison v. State case that was cited in the state's brief. And that went pretty thoroughly through the issue of why a defendant can be found in contempt for refusing to comply with an order, even if it's unconstitutional. And that's to essentially protect the judiciary's ability to make judgments and direct its litigants to do anything. In this case, it was a search warrant without being questioned as to the validity before the orders are carried out. In this case, the appellant could have moved to vacate the order, moved to quash it. There could have been a writ of prohibition, but none of that was done. And instead, it was simply used as a defense to contempt, which the Jamison case specifically goes through why that's improper. So in this case, it was purely a notice of appeal of a finding of contempt, and contempt deals not with the underlying order and its validity, but simply with, was there a court order and was it intentionally disobeyed? And that's exactly what we have here. If we were in a world where we were considering the constitutional merits of the search warrant, then Stahl would be directly on point. As Judge Smith pointed out, there's the existence of the passcode. We know the defendant possesses it, and it's a self-authenticating piece of technology. Stahl is directly on point, and this court would be bound to follow that as its own precedent. However, we're not even here contesting, or we're not here discussing the merits of the warrant itself. It simply is sufficiency of the evidence of a finding of contempt, and the state has sufficiently proven that. So if there are no questions, the state would ask this court to affirm.
Very good. Mr. Hunt or Mr. Atkins?
Thank you, Your Honor. To close out real quick without kind of rehashing anything we covered. Yes, and as a general principle, you can't, it's not a defense to contempt to say an order is erroneous, but there's case law recognizing that orders of certain errors of a certain magnitude can be challenged that way. And I believe constitutional issues like this are of that magnitude. And I know in the context of certiorari and civil discovery, there's a case recognizing that, you can challenge those. Certiorari needs to be available because you can challenge, the only other way to challenge certain discovery orders at least would be through an order of contempt. So that almost implicitly recognizes there's still some room to challenge orders itself, the validity of orders itself through contempt. There's not a blanket prohibition against it like the trial court judge seemed to rule. But yes, it's somewhat limited, but I believe a constitutional issue like this would be of that magnitude. And other than that, I would only be rehashing anything I said previously. So we would ask that the court reverse.
Very good. Thank you both for the arguments. You can exit the virtual courtroom. And the next case on the docket is Springstead Holdings versus Del Prado Mall. I see Ms. Ryan, and let's see, Ms. Mace appears to be in the courtroom as well. And we are ready, Ms. Mace. You may proceed.
Good morning, Your Honors. May it please the court, my name is Christy Mace and I represent the appellant Springstead Holdings Incorporated. At this time, I'd like to request 5 minutes for rebuttal.
Very good.
Thank you. Your Honors, the parties involved in this case are the appellant, who is a commercial condominium unit owner, and the appellee, who is a commercial condominium association. This is a case where the association president erected a permanent structure in an easement on a common area parking lot. This permanent structure consists of a dumpster enclosure, which is on a large concrete pad, and it houses one dumpster container. The walls are comprised of concrete block. This dumpster measures 22.8 feet in width, and on the dumpster are horizontal sliding doors. Now, aside from the width of the dumpster are additional tracks that the doors slide outwards on. And then on the sides of those tracks are balusters that add they go into another space and a half of the parking lot. The total structure takes up about 6 out of 7 of the parking spaces that are located in this common area parking lot. This enclosure is located directly outside of the appellant's laundromat business. His business, the parking lot that is located next to his business is primarily used by his customers for carrying laundry in and out of his business. There is an easement over this parking lot which allows for vehicular ingress and egress. Your Honors, it's most important to point out that the facts of this case are wholly undisputed. Specifically, it's undisputed that the dumpster enclosure was constructed within the easement and that the obstruction is in violation of the easement language that's set forth in the association's governing documents. The language from the association's governing documents, specifically the declaration, specifies that easements cannot be revoked, amended, and shall survive the termination of the condominium. There is no contract.
Ms. Mace, let me interrupt you for a moment. I believe their defense here is based upon the 2016 denial, the judgment, and then the denial of the injunction that was sought in that case. And the question that I have is, in denying the injunction, where they sought to prevent the actual construction of the dumpster, because I don't think it had been completed. I think they had just started with the construction. But in denying the injunction, the court makes a finding that based upon waste management and the facility or the parcel, that there's no other place to put this dumpster. So the question I have is, does that not preclude you from seeking the relief in this case? Because
No,
there
Your
was
Honor.
no appeal from that injunction, from that order.
No, Your Honor, and there was no discovery done in that case. In the 2016 case, unfortunately, there were misrepresentations made to the court by the appellee. It was stated that there was no other location for the dumpster. However, at trial, we had the city testify that there was another, that the dumpster.
Well, I guess, okay, so let me go back. Maybe let me make my question a little bit more clear. The court in the 2016 case denies the injunction to stop the construction and says that there's no other place. And that order was not appealed. Does that preclude you from seeking the relief here? And why? And if not, why not?
It does not. It was specifically, this came up at trial, and it was discussed that we did not get to the merits of the case at that hearing. It was simply a temporary injunction that was being decided. So it did allow us to file a new case, and that was discussed at trial. And for the reasons being that there was a lack of candor with the court. And that is when we were able to further question the city, question Waste Pro, and that is when it's determined that the dumpster could have remained in the grassy area. And so, Your Honors, the only record evidence that we have are admissions from the trial proceeding that the association created the obstruction, which encroaches on the easement, and that the association was aware that there was an easement for vehicular ingress and egress. I'd like to point out that Judge Kyle made two errors in his ruling and when he denied the appellant equitable relief. The first error was that Judge Kyle erroneously stated that the plaintiff failed to show that there has been or will be irreparable harm. Secondly, Judge Kyle pointed out erroneously that the plaintiff failed to show a lack of an adequate remedy at law. The standard that was used by Judge Kyle was not the correct standard, as he considered a standard that is used when property rights are not at issue. The standard used by this court is that an injunction against a violation of covenant restrictions or a violation against property rights may be granted without a showing of a lack of adequate remedy at law or a showing that there has or will be irreparable harm. While both errors made by the court are independent, they are somewhat interrelated. A showing of irreparable harm or inadequate remedy at law is not required when seeking to enforce a property right. In consideration of this standard, there's only one remedy that should be available to the appellant, and that is to remove the obstruction in the easement. I now refer to the case of AutoZone Store v. Northeast Plaza Venture LLC. I'll provide you the citation for that case. It's 934 Southern 2nd, 670. This case is factually similar in that it involved a permanent structure encroaching on parking spaces. This case addressed the standard used by this court when property rights are at issue, and this is what we believe to be the appropriate standard that should be used in our case. In this case, the court held, and I'll read you the specific language that we feel is pertinent. Injunctive relief is normally available to redress violations of restricted covenants affecting real property without proof of irreparable injury or showing that a judgment for damages would be inadequate. And the court's reasoning for this is the value of a restricted covenant is often difficult to quantify and may be impossible to replace. Further, the court held that restrictive covenants have traditionally enjoyed the strong protection afforded property interests by specific remedies designed to secure enjoyment of the intended benefit rather than compensation designed to substitute for its loss. Both restrictive covenants usually are intended to create rights to use or protect specific property, to provide shared amenities, or to maintain the character of a neighborhood. Their value is often too difficult to monetize and impossible to replace without a change of location. Finally, the court stated because of the unique nature of each piece of real property, violations of restrictive covenants cannot be easily remedied by monetary damages. This same standard should be applied to the case presented before us today, as it would be an error for the court to consider any other standard. At this time, I'd like to draw your attention to page 628 of the record. It shows a photograph of the current location of the dumpster. Your Honors, prior to the 2016 case that was filed, the association, you'll see that there's a dumpster located to the right in this photograph. And that was the original dumpster that was used by the association. They had an agreement with the neighboring association. You can see there's a breezeway in the picture. That neighboring association is a separate association. The agreement with that association terminated when there was excess garbage and they weren't maintaining the garbage area. So at that point, when the agreement terminated, the association put a dumpster in this grassy area to the left of the current location. There was no issue with the dumpster being in that grassy area. In 2016, or I apologize, 2018, in June of 2018, Judge McHugh handed down his ruling in the 2016 case. And that there was a case that was filed by the appellant. In that case, the appellant filed a lawsuit against the association for failure to maintain the common areas. In June of 2018 is when Judge McHugh handed down the ruling that the appellant prevailed and stated that the association was required to better maintain the common areas, and specifically stated that an enclosure must be put around the dumpster. There was no language in that final order that required the dumpster to be moved, merely that the dumpster be enclosed. After the 2018 ruling, few months later, Mr. Serpianov, who was a former board president, he was a board president at the time of this matter, he had a very strained relationship with the owner, with the appellant. And out of nothing other than vindictiveness, he decided to move that dumpster, and this was without seeking permission from the city, without seeking approval from Waste Pro, and in violation of the governing documents, and without getting board or member approval, he moved that dumpster to the most obtrusive place that he could possibly put it, and that was in the middle.
What about that circumstance required notice for the board to move or construct the dumpster in the place where you're complaining it was constructed?
Well, first, we would argue that this wasn't even something that the board or the members could have approved, since the declaration specifies that an easement cannot be amended or revoked. But an association decision has to be made by a quorum. Whether it's
is this, I guess, let me back this up. Is this an amendment to the easement? Right. So you're saying that by placing the dumpster in the easement, that it's an amendment?
It's an impediment to the easement. So essentially it would technically, it would almost be revoking the easement, because they no longer have access to these parking spaces. So it would essentially be revoking the easement.
Is there any case law supporting that argument? Because it seems to me that's an encroachment. And there's a plethora of cases that treat these kinds of things as encroachments or restrictions of use of an easement, as opposed to an elimination of the easement.
Yes, there's 3 cases specifically I pointed out in my brief, and those are Richard B. Jackson, BHB Development, and Manel. If I refer just to Manel and BHB Development, both of those cases, there was obstructions put in easements. These were minimal obstructions, and these were obstructions that had a safety-related purpose. So in BHB, the association installed a locked gate on a footpath between a beach and the association,
which eliminated any use of the easement, correct?
It put an impediment on the easement. They now had to go through a locked gate. And the court held in that case that even an impediment was an obstruction of the easement, and the impediment had to be removed. So in some of these cases, there was still minimal access to use the easement, or there's cases where there's a 20-foot wall that is within a 50-foot easement, and they still are able to use the easement, but the court determined that any obstruction was improper and had to be removed. So going back to the photograph again, and going back to the 2018 ruling that was made, as I stated, Mr. Serpianov did not get any approval. He unilaterally made the decision, and I don't know if I answered Judge Smith's question then, but we would argue basically that he did not get approval from the board or the members, and he also moved it in violation of the governing documents, the easement language, to which Mr. Serpianov testified that he was aware that this easement language was in the governing documents. Further, to add insult to injury, when he did move the dumpster to the middle of this parking area, his original plans that were submitted to the city for the enclosure that was required by Judge McHugh's ruling had swinging doors that opened outward. When Mr. Serpianov moved the dumpster to the middle of the parking lot, out of vindictiveness, he decided that he was going to use horizontal opening doors, which took up an extended space. Now, Waste Pro testified this was not required for them. This was, again, just him trying to take up more of the parking area that my client, or that the appellant, primarily used for his customers.
Ms. Mace, you are just about at your 5-minute mark.
Thank you, Your Honor. I will rest for right now.
Very good. Ms. Ryan?
Good morning, Your Honors. If it please the court, Tricia Ryan for the Appellate, Del Prado Mall Professional Condominium Association. The appellant had filed their amended complaint in the underlying case on January 15th of 2020. That complaint contained 3 counts. Those counts were breach of contract, tortious interference with the business relationship, and injunctive relief. There are claims on the breach of contract. I apologize if I may go back. The trial court, after weighing and considering all of the evidence admitted at trial, including testimony and exhibits, found that the appellant failed to meet the requisite burden of proof for each count. The trial court's determination of whether the plaintiff meets its burden of proof is a determination of fact. Pursuant to Sarasota Citizens for Responsible Government versus City of Sarasota, Florida, that's at 48 Southern 3rd, 755 at 761. That's a Florida Supreme Court 2010. And Liner v. Workers Temporary Staffing, Inc. at 990 Southern 2nd, 473 at 476. Also, Florida Supreme Court 2008. There is a presumption of correctness to the trial court's findings of fact. In their breach of contract claim, they claimed that the association failed or refused to set annual meetings. They failed to provide notices for meetings. They failed to hold board meetings to make and execute board decisions. And they failed to prepare annual budgets. Nowhere in this claim for breach of contract did they raise an issue or claim for an encroachment of an easement.
Ms. Ryan, let me ask you a question then. One of the things in going through the record that I found is an agreed pretrial statement. And I recognize that you're saying they you had no notice that this was an issue, although I think there's some facts that show otherwise. But the agreed, let me just read it to you. It's an agreed uniform pretrial conference trial order. The record page is 255. And it says, SHI's claim is that a dumpster pad and enclosure was wrongfully installed on the common area in the association, and as such must be removed. And then it goes on to say what the defense is, basically that defendant defends on the ground that a previous Lee County, Florida case ordered the installation of the dumpster pad and enclosure, and contends that the court in the prior case has previously ruled in the other case regarding the placement of the dumpster. And so it's hard to argue that lack of notice. And in fact, I think there was really consent that this issue was tried. There's some further evidence that I saw of the written closing that had this issue that was raised. But I guess one of the questions that I had was, I didn't see a written closing from your client in the record, and I didn't see an objection. So I'm having a hard time seeing where this issue wasn't tried by consent, especially where I just read to you the agreed pretrial statement.
Yes, Your Honor. The pretrial statement references common area. It does not say anything about an encroachment on an easement for ingress and egress, and that is what they are arguing. There's a lot of common area. The sidewalk is common area, is common element.
Well, didn't they, I mean, the plan that showed where the dumpster was located, and this says wrongfully installed on the common area. And I think and through the discovery and the trial testimony, isn't there only one dumpster pad on the common area?
Yes, Your Honor, there's one dumpster pad, but again, at no time during the entire 3 years of this litigation was a reference made to the ingress and egress easement. It just referred to it as common area. If they had put us on proper notice as required by case law, not only of this court, but the Florida Supreme Court and the Florida Rules of Civil Procedure, we would have been able to prepare a defense for that.
Well, didn't the president of the association testify to the easement and that he knew that the dumpster was in the easement? Wasn't there some testimony on that? And then I think the written closing. And so then we're left with that. There's no objection in the record to the written closing to this testimony and the relief that they're seeking. So I don't see anything from your client that shows an objection other than what we see now in the brief.
Your Honor, again, the reference to the easement and the testimony of Mr. Serpianov, that was the first time this was brought up, was at trial. This was not something that was brought up at his deposition.
Yep. So was it objected to at trial as far as relevancy? Because I didn't see that in the record.
No, Your Honor, we did not object to it at that time.
But wouldn't that have been the time and place to object to that?
I wouldn't necessarily agree with that, Your Honor. We could have objected to that at the time, but at the same time, as far as the closing arguments go, the instruction was from the court, we could do a closing argument or we could do a proposed final judgment. And the final judgment would include our closing arguments. And the final judgment that I presented to the court is the one that the court entered. The court did make adjustments to it to specify specific findings of the court. The court listened to all the arguments. The court had the opportunity to listen to the testimony, to review the exhibits, everything in its totality. And the court made the factual determination that the appellant did not meet their burden of proof. The court specifically said regarding the injunction itself is that the appellant failed to show any competent, credible evidence that there is no adequate remedy at law, that there would be irreparable harm if an injunction is not granted, or that the injunction would serve the public interest. Again, this is an association, Your Honor, that we're talking about one stretch of a parking lot that was not specifically, and this has been ruled on in the 2016 case in the injunctive, that parking lot was not put there for the sole use of the appellant. There is over
Wait, are you
400
talking, are you talking about the front parking lot or these spaces?
these spaces, Your Honor.
Okay,
The court specifically determined that that's not there just for his use. And the trial court determined that there is adequate parking in the front of the building. The appellant failed to provide any testimony, any evidence, any witnesses that shows that there is an impediment to his business. And that is the crux of his case. He's claiming an impediment to his business based on the dumpster. And he failed to show that.
well, I mean, that's the tortious interference count, but there's also a breach of contract that had to deal with the declarations. And I guess that's kind of my focus. If this issue was tried by consent, and I don't see any finding from the court on the actual location of the dumpster, that kind of concerns me, because then there is evidence in the record about the easement and an admission from the president that the dumpster was in the easement, right?
Again, Your Honor, in their breach of contract claim, they made no claim about the dumpster. The breach of contract, they were claiming no annual meetings, no annual budget, no meeting notices, and no meetings to approve business of the association. However, the testimony did show and was presented by Tim Serpanoff and Carlene Monroe, who were both past presidents of the association, and testified that meetings were held. It is even in the record, Your Honor, that there was a meeting to discuss this dumpster. The record is clear that the association, they called the meetings, they noticed the meetings, but they couldn't always get a quorum. They had a very difficult time.
Ms. Ryan, let me ask a question on that. Actually, there are two things I want to ask questions on. One is in the general allegations of the complaint, there are two paragraphs that refer to the dumpster being constructed in the parking lot immediately outside the plaintiff's business, and that it affects the business of the appellant. And the general allegation is incorporated into each of the subsequent allegations. So there's at least some suggestion in the complaint that the easement is in fact, or the violation of the easement, encroachment of the easement is in fact an issue because of the causes of action that are then raised, which include breach of contract and tortious interference. The other thing I wanted to, and that's really not a question, but that sets up the question. The trial judge in the final judgment acknowledges the testimony that meetings were duly called and noticed, but the judge never makes a finding that a quorum in fact was present. The judge just doesn't address it, but by implication, it seems the judge is acknowledging, well, maybe quorums weren't present, but the meeting was duly noticed and called. Is a notice of a meeting sufficient?
Your Honor, that is what the association is required to do by statute in the governing documents. There's nothing.
Wait. Is required to do what?
To notice meetings.
And then do the governing documents require a quorum to conduct the business of the meetings? There's no requirement whatsoever for a quorum.
Well, a quorum has to be there to do a vote, to really hold a vote for anything. But Your Honor, there's nothing in the law that requires an association
if a quorum is required to conduct the official business of the organization, is there evidence that a quorum met and approved the work for the easement or the work for the dumpster going in that location?
Well, Your Honor, the testimony states that there were 2 board members present. It's a 3 board membership. So that shows that there's a quorum.
A quorum for the board. Was this an action that was required to be taken by the board or the membership?
The board, Your Honor. However, I would also argue that the board really doesn't have a lot of say in it because they had to follow the court order to construct a dumpster enclosure.
But the enclosure was going to be in a different location than where the dumpster is presently located. Is that correct?
No, Your Honor. At the time of that trial and that determination from the court, there is nothing in the record in the judgment that says where the dumpster has to be.
But wasn't the dumpster already existed in a spot, right?
Your Honor, it was in the
It's either yes or
spot-
no. Counsel, it's either yes or no. Was the dumpster on site?
It was on the neighboring association's property,
So there was no dumpster in the current location.
not
At
in
the
the current
time of the
location.
trial. Okay.
Not in the
So
current location.
when the judge ordered construction of an enclosure, that was in reference to an existing dumpster in an existing location.
I don't know if I understand your question correctly.
The judge said there's a problem with the dumpster, and that was an existing dumpster, right?
Correct.
And the judge
dumpster-
said, clean it out and put an enclosure around it. Is that right?
Yes, Your Honor. At the
Okay.
time of the, at the time.
And
of
at
the
that
judgment-
time, the dumpster was in a different location.
Yes, Your Honor.
Okay, thank you.
And as far as that goes, Your Honor, during the course of that trial, the dumpster did get moved. It was moved several times. It didn't have a set place. Every place they moved, it was an issue with the city and with Waste Pro. So when they finally got the location down, that's where they started constructing the dumpster. And we had the preliminary injunction, the hearing, and their injunction was denied. At that time, it was the understanding of the president of the association that that's the only place that both the
You seem to have lost either you've gone on mute. There you go.
I apologize, Your Honor. I hit a button and it muted me. At the dumpsters in the location where the court denied their preliminary injunction. At the time, it was the understanding of the then current president that that is the only place that Waste Pro and the city were both in agreement that it could be. That was his understanding at that time. As far as counsel's argument about the changing from swinging doors to sliding doors, nothing was done in a retaliatory or in any way a deliberate purpose. The decision to change the doors was based on conversation between the then president and the drivers for Waste Pro, who suggested to him that it was easier for them to have sliding doors than swinging doors. Doors are open, swinging. A strong wind comes through, it closes the door. So it makes it a little more difficult for them. Again, Your Honors, I would argue that there was no reference, although it was referenced common area and it said parking lot, there was no reference to the easement. Nothing was ever mentioned about easement during the 3 years of litigation until we got to trial. Even when we went to deposition of Tim Sopianov, nothing was mentioned about easement or encroachment in easement or the documents within easement. This was thrown at us at trial, and it was never incorporated into the actual complaint. The complaint for injunctive relief was in violation of governing documents and Florida Statute 723-085. The governing documents are over 40 pages long. So there's no specific notice as to what in the governing documents they're referring to. And Judge Kyle specifically determined that there's nothing in Chapter 723-085 that the association has violated. The appellant is asking you here today to overturn the trial court based on allegations that were not properly pled in its complaint. They were not mentioned any time during the 3 years of litigation until we came to trial. Even in the pre-trial conference order, the easement itself is not listed. The encroachment on the easement is not mentioned. It simply says common element. There are a lot of common elements on this property. Understandably, the common element that they are talking about is that back parking lot, but at no time do they reference the easement to that back parking lot, just that it's common element. They are asking you to overrule the precedent set by this court and by the Florida Supreme Court. This court said in that was the Florida Supreme Court, in GGB Profit Sharing Partnership versus Goldberg, 166 Southern 3rd, 847 at 849, Florida 2nd District Court of Appeal in 2015. They reached the conclusion that the claim in paragraph 6 of that could not have put GGB on notice that Goldberg was alternatively seeking a percentage of the insurance proceeds as a trust beneficiary. This issue is similar to our case. Claiming common element, claiming without claiming an actual breach of an encroachment or violation of a specific clause in the article or the declaration does not put proper notice on the defendant in order to prepare a proper defense or to
Ms. Ryan, I guess I don't see how you can say that when the agreed pretrial statement says that SHI's claim is that the dumpster pad and enclosure were wrongfully installed on the common area. I just don't see how you can make that argument.
Again, Your Honor, it's improperly installed on a common element. It does not say anything about encroachment on an easement for ingress and egress. It does not anywhere reference the paragraph in the declaration that they were bringing forth at trial. It was not proper notice. If they would have specifically stated what they were claiming as improper, just saying improperly installed could mean anything. It could mean the size. It could mean the direction that it's facing.
Okay. And then when they did written closings, there weren't, this is still part of the trial process. And they did written closings and they gave all of that information that you're complaining about, but there was no objection raised to that written closing.
Your Honor, my objection.
Ms. Ryan, you can answer that question, and then you're at the end of your time.
Thank you. The objection was in the form of our proposed final judgment based on the four corners of the complaint. And that is how Judge Kyle ruled, was based on the four corners of the complaint that they improperly pled what they were trying to argue at trial for the first time.
Very good. Thank you, Ms.
Thank
Ryan.
you.
Ms. Mace?
Thank you. Your Honors, in response, I want to touch back on Judge Smith's question regarding the appeal of the temporary order. I want to cite to a case, Clack v. Eagles Reserve Homeowners Association, and that citation is 862 Southern 2nd 947. And in that case, this court decided that that because a temporary injunction is by its very nature provisional, that it would be nonsensical to give a binding effect on the subsequent proceedings in the same case, even where the tentative determination of a trial court has been the subject of interlocutory appellate review.
Let me ask you, Ms. Mace, is that a case that's cited in your brief?
I do have that case in my brief. I do not have that case in my brief. I just have it here in some of my case law that I was going over. but I believe it gets to the same rationale that was argued at the trial. But I did just want to point that out, that this court has had that rationale.
Let me follow up on something Ms. Ryan had left with in her argument, that the court addressed in its final order the issue about the easement not being properly pled. Is that something that appears in the order that the trial court entered?
I apologize. Could you clarify that question?
Yeah, is there anything in the trial court's order that discusses that the issue of the easement wasn't tried by consent or was improperly before the court because it wasn't properly pled in the complaint?
Are you referring to the 2016 order or the
No,
the 2018 order or the final judgment?
Yeah.
There
order
was
that
no
we're here
mention. There was no mention of any of the facts being improperly pled. And I think, as you correctly pointed out, that Ms. Ryan had, multiple opportunities to object. She actually raises the case of GGB, and in that case, it actually, I would distinguish, it actually works to our favor, because in that case, the defendant properly objected at the time of trial, which Ms. Ryan failed to do. As you stated, we had a stipulated statement of facts. She had the opportunity at trial. She had the opportunity in post-closing statements, and not one time did she ever raise an objection. And there's case law, Plicta v. Plicta, where an objection was raised on the first time on appeal in a reply brief. And the court said that those issues will not be properly heard before the court and will not be considered. There's also the 24-hour collection case where the court determined that it was reversible error when no objection was raised as to unpled issues, and that those issues should not be before the court. So ultimately, Ms. Ryan waived her ability to object, and under Florida Rule of Civil Procedure 1.190, there was implied consent. And I even argue that these facts were pled in our original complaint. It clearly stated in our complaint that the association was not abiding by the governing documents. And that is the crux of our argument. I also want to touch on the fact that Ms. Ryan was asked where the dumpster was located when the 2018 ruling was made, and she stated it was on neighboring property. That is not correct. When the 2018 ruling was made, that dumpster was located on the grassy area. And if I have no questions, no further questions from the court at this time, I would respectfully request that the court reverse the final judgment and remand with the direction of a final judgment in favor of the appellant to remove the obstruction from the easement.
Very good. Thank you, Ms. Mace. Thank you, Ms. Ryan. That concludes the presentation on that case. The next case is Bain Complete Wellness versus Garrison Property.
Judge Silverman?
Yes.
I believe Attorney Jackman may have had some technical difficulties. Looks like he dropped off, but I have a telephone caller, so I'm going to allow them to talk, if that's okay.
Okay, so is he is he present by phone?
I believe he's present by phone, but in order to confirm, I need to allow them to talk.
Okay.
Okay.
Mr. Dutton, stand by. Mr. Jackman, are you here?
He may need to unmute himself.
Your Honors, this is David Jackman. I'm having some technical issues. I apologize. You guys hear me?
Mr. Dutton and Mr. Jackman, we have two other cases on the docket. I do not mind switching the order if you think you can get the technical difficulties fixed. If not, you can proceed with the audio.
I would prefer, if possible, to try to rectify the issues.
All right, we'll pass the case for the moment. Mr. Dutton, I apologize, but if you don't mind, we will give Mr. Jackman the chance to fix the problem and the hope that he can do so. So we can.
Yeah, I'm in the process of switching devices and I've switched internet connections twice, so I don't know what the issue is. I
Very
apologize.
good. So,
I'm sorry. To be back before the court at what time, please?
I'm sorry, Mr. Dutton, what was that?
To be back before the court at what time, Your Honor?
Well, let's plan on, it's 10:40 now. I'm going to go to the fourth case, which, depending on how long the lawyers argue, means we would probably not get back to you until somewhere around 11:15 or 11:30. We'll take a 10-minute, and let's do this. After the next case, I'll take a 10-minute recess, and that way you all can sort out where you are with the marshal's office and the clerk's office. But I'm figuring you won't be back until somewhere close to 11:30 at the earliest.
Thank you so much, Your Honor.
Very good. So Mr. Dutton,
Thank you,
Mr.
Your Honor.
Jackman, you're welcome. We'll have you exit the courtroom and then we will proceed with Delcourt Development versus the City of Marco Island. And for everyone else that is on this, after the Delcourt Development case, we will take a 10-minute recess. But let's proceed with case number 4. Mr. Rosengarten, I see you. It looks like Mr. Vesely is now on board as well. I apologize for the last minute switch in cases, but I know you all have practiced quite a bit, so I think you can go with the flow. Mr. Vesely, you're up. Are you okay to proceed?
Yes, Your Honor.
Keeps us on our toes, Your Honor.
Very good. Thank you both. And let's go ahead. Give me just a moment here to reset the clock. All right, Mr. Vesely, you may proceed.
May it please the court. I'm Brandon Vesely of the Florida Appellate firm. I'm here on behalf of the petitioners, Delcourt Development LLC and Southdale Incorporated. I'd like to reserve 5 minutes for rebuttal, if that's okay.
Very good, Mr. Vesely.
Thank you, Your Honors. As I mentioned, this is a petition for certiorari on second tier certiorari. Just to kind of give you a brief background, this case involves the expiration of a site development plan. My clients were interested in building a building in downtown Marco Island in a commercial / residential district. They obtained the permission from the city council to have a conditional use, 75% residential, 25% commercial. They then fast forward, I'm going to give you the dates, but they basically fast forward to when they applied for the site development plan. They obtained a site development plan, and really the crux of the issue in this case is whether that site development plan expired prior to their opportunity to build their building, okay, to obtain their building permit to build the building. So there's a lot of code provisions that are relevant and some statutes that are relevant. We'll talk about those. But kind of now going backtrack a little bit on the facts. This was back in January of 2015. The petitioners were granted the conditional use for this building in the commercial district of Marco Island. Again, it was 75% residential, 25% commercial. And that's very important because the nature of this building, it wouldn't be feasible for them to build it. They testified to build it at 50-50, which is what the code ultimately changed to after they obtained their site development plan. So they submitted for their site development plan on December 8, 2015, again, 75-25. It wasn't granted until February of 2017, but it was granted. So they did obtain approval of their site development plan at the 75 residential, 25% commercial. So they're off to the races now. You'll understand that the code basically has provisions that say you have to do certain things within a 2-year period in order to have that site development plan be effectuated or confirmed. So they, our claim is that we did them. They're going to claim that we didn't do them. But So all of this occurred in 2017 to January 18th of 2019. There was some activity going on. In November 2018, my clients, this is before this site development plan expired, they inquired about possibly getting an extension. The city manager and the city told them, if you're going to get an extension, we'll grant you one, but you're going to have to do it under the new LDC, the Land Development Code, and that's 50-50 on commercial residential. So you're going to have to amend your site development plan. They didn't want to do that, obviously, so they quickly got their act together and filed for their building permit in January 18, 2019. Okay, so additional documents were submitted in the ensuing days, all before the expiration of the site development plan. They thought they were in good shape. On March 5th, 2019, they get a letter from the city, and they submitted that building permit, and they're waiting for a result on it. On March 5th, 2019, this is now after the expiration of or would be the expiration of the 2-year site development plan, had they not done what they were supposed to do. But as we're going to claim later, they did do what they were supposed to do. But let's just say that 2-year period came and went. And by March 5th, 2019, they get a letter from the city, and the city says, hey, we're reviewing your building permit. Okay. So on March 6th, 2019, the next day, city had a change of heart and said, nope, your SDP expired, no deal. You're going to need to file a new one under the 50-50 breakdown. So what happened after that? The petitioners appealed. Again, they can't do the 50-50, so it didn't make sense for them to do it, but they did file an appeal. The appeals of the city manager and the city's decisions go to the city council. So this is the appellate process that they've designed in their city. That goes to the city council. The city council then has to review it under a quasi-judicial proceeding, an appellate type proceeding. And there's a lot of questions on how that's done, if it's done properly in this case or not. There's a lot of questions on the procedure, the proper procedure. And there's a transcript in the record. You can read it. It's not very long. It's about 70 pages. In the record of the, let's see, I'll give you the sites in case you want.
Mr. Russell, let me see if I can get to what I think is a critical issue for our review, which is we're here on second tier cert, which, as you well know, is a very narrow scope of review. So specifically, how did the circuit court fail to comply with the dictates that it must follow for purposes of our taking review of this case?
Yes, the second tier cert, we're looking for due process. Obviously, that was not a problem in the circuit court on the first tier certiorari. And then a departure from the essential requirements of law is the second part of it. So we're saying that the trial court departed from the essential requirements of law by not doing what it was supposed to do, and that is looking at the due process standard, applying a due process standard to the appellate proceeding that occurred, and also disregarding the law. There's several different statutes that we're contending the trial court didn't applied incorrectly. So let's start with that. Let's first address what you said at the very end there. Applied it incorrectly. If the circuit court applied the proper law incorrectly, as harsh as it may be, do you agree we do not have certain jurisdiction to correct mere legal error by the circuit court? If they didn't apply it at all, I believe, and also for due process rights that were totally eviscerated in the.
You said, though, that due process in the circuit court is not an issue.
Due process in the circuit court is not an issue, but he's reviewing the due process that occurred in the trial. I mean, it's almost splitting hairs, but the truth is he has a responsibility to review on first tier, whether the procedural process, due process was accorded. That's his responsibility. And if he doesn't, he doesn't.
The test for us is not whether the trial court or the circuit court got it right or wrong. The test for us is, was there a complete failure to apply the proper law, right?
Right. And,
Okay.
and I believe that
So
happened.
is your argument that the circuit court failed to apply the proper law?
Yes.
Okay. I just want to make sure we're approaching this from the same way,
Yes.
because candidly, as I read the briefing or the petition, the arguments really sound like the counsel or I know I'm not saying the right name for the organization, but the body did not act appropriately in reviewing your client's applications and in handling it and so forth. The city did not do so, which is very different to me than what I think you're trying to argue, which is the circuit court totally missed the right law on this.
Totally missed the right law, and the law that the circuit court totally missed was whether due process was afforded at the lower level. That's what the trial court missed. That's what the trial court didn't appreciate and didn't rule upon properly. I mean, the one thing that he did say, and one of the arguments that we raise is, look, in order to have due process, you have to be able to know what the reasoning was in the counsel's decision. And he says, well, their reasoning was that that it's harmless error. They didn't write anything down. There wasn't a written a ruling, but it's harmless error because I have a copy of this transcript. And so if you look at
the first, actually, it's the last paragraph of the judge's order, but it's really the first, what I would call substantive ruling paragraph. And the first thing the judge says is the court concludes that the city accorded procedural due process under prong 1, and that the findings are supported by competent substantial evidence under prong 3. So it seems to me that, again, your argument is the judge referenced the right law, and the judge may have made an incorrect decision in referencing or applying the right law. But how does that amount to a failure, an absolute failure to apply the correct law? Not apply the correct law correctly, but to a failure to apply the correct law.
Not apply the law incorrectly. He didn't apply the law at all. Just because he says that there's due process because he's looking at the standard doesn't mean he applied it. I mean, there was no application of the due process standards, because if he had applied the due process standards, he wouldn't have possibly gotten to the result he got to, because there was no written order from the city council, because the city council, the people that were making the decisions were actually the ones testifying in the case, because the city council allowed the city attorney to not only testify but influence their decision in acknowledging that he hadn't even read the submissions that were submitted on the appeal. So these people were allowing the city attorney to basically make the decision for them when he never even read what was presented. So all of these things are things that when you look at, I don't think we have to ignore the record just because the judge mentions due process. I think we look at the record and we identify whether the judge actually applied the law. And the law is, there's no way you could get to that result. There's no way that you could conclude that there is due process in this case. Was there
any objection to the manner in which the proceeding occurred before the city?
All right. Officially, there was no objection, but that doesn't mean that you should have. I mean, are you going to say that in a circuit court case is fundamental error if a judge starts testifying? That's fundamental error. You don't need to object to that. I mean, I think that's the stage we're at in this case. It was so egregious. We have 3 of the council members providing testimony. The city attorney providing testimony. The city manager is the party, that he's representing the city in this. I mean, we're talking about.
And nobody felt that there was a reason to object to the manner of the proceeding when both parties seem to be perfectly willing to let the city hear this. I don't know if I'll call it a proffer. Maybe it's a proffer, but bottom line is multiple people are talking. Multiple people are asked, do you have any more questions? Do you have anything you want to add to this? And nobody says, wait a minute, we think we're in opening arguments. We didn't realize you're treating this as testimonial. So you can cast a lot of blame on how this happened, but at the same time, it seemed like everybody was very happy with how the proceeding was taking place. So I'm a little troubled by the argument that, well, this is so bad, we have to exercise second tier cert, when nobody seemed to have a problem with it at the time it was taking place.
Well, I think counsel for the petitioners was taken aback by how the proceedings started out. He didn't even get to go first. You know, I don't think that's something that you
acknowledged that, and he acknowledged that, and then said, "But that's okay." So, yeah, Mr. Vesely, you've been around a long time. You've appeared in front of us many times. So, as I look at this, I'm really concerned about the fact that everybody acquiesced in how this was proceeding, and it may not have been the best procedure, but nobody seemed to be unhappy with it until the result came out.
Well, that's okay. So I believe that you have fundamental error going on here, and I don't know if Mr. Davido objecting to that would have made any difference at that point, because it was already out. You know, we're going to start the proceeding over again. I mean, it's fundamental error. That's what gets handled on appeal. Okay, for having the adjudicators in the case. The appellate judges, if you will, make the decision, but they're also testifying about what happened, things outside the record. I mean, it's absurd. And then you have the city attorney talking about what he believes, what they didn't present when the information was presented to him, and he never even reviewed it. So we're talking about 300 plus pages of documents showing building activity that was going on at the time. And so, but that's the one argument. Okay, I feel like that was certainly overlooked or departure from the essential requirements of law. But I also feel like the trial judge, the circuit judge failed to recognize the correct law that applies in this case. And then if he would have done that, then he would have reversed it as well, because the correct law that applies in this case, which seems to be lost on the city council, was well, it comes, first of all, you start with section 3679 from the land.
Mr. Vesely, go ahead and you can finish your thought, but you're at the 5-minute mark. So go ahead and wrap up if you would.
Okay, I just want to talk about this real quickly. The 30-679 of the Land Development Code talks about what has to happen before that 2-year expiration. And it talks about development and actual construction. Development is then not defined specifically, but they say development is defined as having the meaning in the Florida statute 380.04. And if you look at that statute, the statute says that the term development is carrying out any building activity. Well, the board, the city council, was sitting there looking at 300 plus pages of building activity and somehow made the determination, the three of them, that didn't qualify. So if they would have presented their written findings, we would have been able to challenge that directly and say, hey, you didn't give us written findings. How did you come to the conclusion that that's not building activity? And that's what they needed to do. What I'm asking this court to do is to issue an opinion that sends it back to the city council to allow them to apply the proper procedure, to allow them to reconsider the evidence under the proper law, which they didn't do. And in the meantime, give a course in the opinion that explains how a city council is supposed to handle an appellate proceeding, because we have people on this city council that had never been in one before and said it on the record. I don't know what I'm doing. Please, I'll follow what you say, city manager. And the city manager is like, he's the opposing party. So I'll save the rest of my time for rebuttal.
Very good. And I'll leave you with 4 minutes. You're down to about 2, but I'll give you the extra couple minutes.
Thank you very much. I appreciate it, Judge.
You're welcome. Mr. Rosengarten, of course, if you need a couple extra minutes, I'll extend the same courtesy to you.
I appreciate it, Your Honor. And still good morning. Again, may it please the court. My name is Richard Rosengarten with the law firm of White Sirota on behalf of the respondent, the city of Marco Island. Judge Silberman framed the discussion, I think, the same way I was planning on framing it, which was to focus on the standard of review, which I understand the panel is sensitive to because we're already talking about it. And we're not here on direct appeal, we're on second tier certiorari review. And this really matters here because all of petitioners' arguments that the city council denied them due process, the application of the statutory definition of development to the factual record, estoppel, these are mere repetitions of the same arguments made before the circuit court on first tier certiorari. And as I can tell the court is well aware, the inquiry on second tier review is much more limited, and I'd like to dwell on it some. The departure from the essential requirements of law requires more than mere legal error, as Your Honor recognized, and appellate courts, do not review the correctness of the circuit court's decision. It has to be something sufficiently egregious or fundamental to fall within the limited scope. And I think given this framing and the panel's questions, I'd like to focus on what exactly that means and give some examples in the case law cited in our response. So when we discuss the standard of review, the cases we cite give some examples of what can be, sufficient to merit second tier and what isn't. We cite the case of IV, the Allstate Insurance Company, on page 15 of our response. And that's an example of the Florida Supreme Court saying this was not proper second tier review. And that was a case where the question was whether a plaintiff was entitled to attorney's fees in an action against her insurance company for PIT benefits. And it was second tier, I think, coming up from review of a county court decision as opposed to administrative decision, but the same second tier standard. So the circuit court, sitting its appellate capacity on first tier in this IV case, said the plaintiff was entitled to attorney's fees under the statute. And the third district on second tier disagreed, granted certiorari relief concerning, concluding she was entitled to attorney's fees. Disagreeing, countermanding the circuit court, saying the circuit court got this statute wrong, she is entitled to attorney's fees. And so the Florida Supreme Court, it made it up there, said this was improper second tier review because the district court sitting in second tier just disagreed with the circuit court's interpretation of the statute. And it was wrong second tier relief. I'm going to quote, because the established law provided no controlling principle and the resulting monetary loss for Ms. Stilson, the plaintiff, while unfortunate from her perspective, is not sufficient by itself to be a miscarriage of justice. And the court also said, the Florida Supreme Court in Ivey said, there's a great temptation in a case like this one to announce a miscarriage of justice, simply to provide a precedent where one is needed. But such an interpretation would invite certiorari review of a larger number of the appellate decisions issued by circuit courts. So there's an example of, circuit court just gets a statute wrong. And the Florida Supreme Court says, maybe, but that is not proper second tier review. And the other case that we cite to give the counterexample of what would merit second tier certiorari review, we cite Nader versus Florida Department of Highway Safety and Motor Vehicles, also on page 15 of our response. And this was an administrative suspension of a driver's license. So a driver refused to submit to a breath test, and her argument in the administrative proceedings was that the implied consent warning waiver document that she was presented was improper because she was asked to submit to a blood, breath, or urine test when the statute just said breath test. So there's legal argument. The circuit court sitting on first tier, and this is within the second DCA, the circuit court sitting on first tier basically disagreed with the driver because this consent warning that she was given, although she says it was improper, it was pursuant to statutory language, and it was on this statewide form used by the Department of Motor Vehicles all over the state. But the circuit court granted certiorari relief in her favor, even though it disagreed with her, because there was this decision from the fourth DCA holding a license suspension should be reversed under an ambiguous warning that was given to her like this. So the department takes it up to the second DCA on second tier review. And the second district granted certiorari relief, countermanding the circuit court because it reasoned that the circuit court, while noble in its effort to follow, the 4th District precedent, directly contradicted the controlling statute and had, quote, dramatic statewide ramifications. Namely, that if it had to deny cert, then every license suspension would have to be overturned based on the 1/4 DCA opinion, which could never, and it would prevent multi-district review from ever happening. And it would prevent the ability for district courts to reach conflicting decisions, thereby making it to the Supreme Court one day and being resolved statewide. So the reason that the Florida Supreme Court found that this was a proper grant of second-tier certiorari relief, it was because a couple things. It was a sufficiently egregious and fundamental error where it just completely contradicted the language of the governing statute. And it was because of the seriousness of the error, having these dramatic statewide effects of causing every single driver's license suspension to have to be reversed and preventing multi-district review of an issue and creating this strange procedural quagmire. And the second, and the Florida Supreme Court was careful to point out, it noted that the 2nd District, quote, did not reanalyze the application of the law to the facts, close quote. So there are examples, and I thought it was important to get into because Judge Silverman, I think in your discussion with my colleague, Mr. Vestley, kept on mentioning the complete failure to apply the proper law. And I think even on scrutinizing the Florida Supreme Court case law on what can be sufficient to rise to the level of second-tier certiorari, I think even that is not sufficient because they make quite clear that it's not just the incorrect application of the law or the failure to apply the proper law. There even needs to be something more. It has to be an error that's so egregious and fundamental. And on top of that, has to have some kind of a serious gravamen to it. And again, there was one identified in that one case, whereas you have the Ivy case where the Florida Supreme Court said they may have got it wrong, and this may have been a very unfortunate situation for the petitioner who had monetary loss, not something we can call a miscarriage of justice. So I think that with that standard of review, having gone into it a little bit more, it helps this court recognize that second-tier certiorari relief is not available here because it's all of petitioner's arguments are really just alleging mere legal error, and they're a repetition of arguments they've been making all along. And I'll go now into the due process argument. Excuse me. So for the due process, again, I think as everyone recognized, it's not a question of the circuit court committing a due process violation. It's really a repeat of their first tier argument that they were deprived of due process before the city council. And with this as the other arguments, I would say it's a second bite at the apple, but it's almost like a fourth bite at the apple because, as Mr. Vestley acknowledged, the proceedings before the city council were itself an appellate proceeding. And so first there's a decision by the community development director that the site development plan expired. Then there's an appeal to the city council of that decision. Then there's a certiorari appeal to the circuit court sitting on first tier. And then there's a petition here at the second DCA. And it's clear that here petitioners just disagree with the circuit court because they make the same arguments. And by the way, the point that it was an appellate proceeding, I think is very important both to their due process argument and to their and to the petitioner's argument that written findings were required. The governing code in the city of Marco Island, section 30-974, and that can be found in appendix 496. And petitioners concede this, make clear that it's an appellate proceeding and it's not a fact-finding proceeding at all under the city code. the city code allows the city council to, quote, affirm, overrule, or modify the decision of the community development director. And, you know, in the record, and this was something that, I mean, there was a discussion of what the circuit court recognized in its order, the record below, it wasn't just a transcript. You know, starting at Appendix 626, there was a city council staff report, you know, authored by the director of community affairs. I've been saying development director, I believe it's the director of community affairs, explaining the decision, explaining the reasoning. There were written submissions to the city council. There was a full transcript of what everyone was talking about. And so there's really no question of what the reasoning was. And I think just to close out the procedural due process point, because I think, you know, the court recognized, I think it's very salient that, I mean, the petitioners do not even attempt to address the waiver issue in their briefing. This was the city's argument all along below. They know that this is the issue. There's really no attempt to deal with it in the petitioner's reply. And I think one of the most salient points, you know, in addition to what Judge Silverman recognized about how Mr. David out below said, you know, okay, he recognized what was happening. He said it was okay. I mean, even as the point to examine and cross-examine witnesses, petitioner's counsel at the city council hearing, you know, introduced its representatives to the city council 4 times and repeatedly offered to have them speak if the council wished to hear them. And then they did speak at some point. And all of the things that, you know, petitioner's counsel is referencing in terms of the city councilors, you know, supposedly testifying. I mean, we addressed that in our response, and I'll rest on that. I mean, it's really not the case. You know, it was an open dialogue. Most of what they cite occurred after the opening presentations were made. And again, there was no objection to anything made. So there's this clear waiver. But I think bringing it back to the standard of review, I mean, again, it's this court, as the court knows, does not undertake a de novo review of what happened in the city council hearing. It's just a question, there's really no showing here that the circuit court somehow applied the wrong due process law or did so in such an egregious and fundamental way with compounded seriousness on top of it that merits second-tier relief, especially when you consider that the record before the circuit court reflected this clear waiver on the part of the petitioners. And just a footnote on, you know, my colleague, Mr. Vesley mentioned fundamental error. There is no briefing on that before the court. Moving on to their argument that the city council is required to enter written findings. Again, this is a repeat of the first tier argument. And the circuit court correctly rejected this argument, as I noted, you know, because of the record that was before the circuit court, as the circuit court recognized, but more importantly than that, I can't stress this enough, there is no requirement in law that the city council enter written findings. There is no code provision, there is no statute, there is no case law that says that this has to happen. And so the circuit court could not possibly have violated the fundamental or the essential requirements of law in rejecting the petitioner's argument in this respect, because there is no requirement in law at all. The petitioners rely on the Broward County versus GBV case, but in doing so, the petitioners are simply mistaken. That was a Florida Supreme Court case where the court was critical of an administrative agency not entering written findings. But the Florida Supreme Court reiterated precedent that no such findings are required. And it recommended that legislation be developed to require written findings in administrative agency hearings. And a statute was passed, but that statute only applied to a limited subset of administrative hearings and specifically excluded from its purview administrative hearings dealing with building permits. And if the court looks, the petitioners tried to rely on the statute in their reply brief on first tier. They've abandoned that on second tier. They do not rely on that statute on second tier, I think, because it became clear during the hearings below that that statute specifically excluded this type of administrative hearings from its purview. So from again, the circuit court could not have possibly violated the essential requirements of law in rejecting petitioner's argument that written findings were required, because there is no legal requirement that they had done that. And just to stress again, as a footnote on the end of that point, I mean, the city council hearing was an appeal. And under the code, it was only obligated to affirm, overrule, or modify. There are, they raised a couple of other points, which I'll address since I have the time. The other argument is about the meaning of development under the statute. And again, this is a repeat of the first tier argument that the city council wrongly read the definition of development to conclude petitioner's site development plan expired. And again, it's just not proper on second tier, because it's really a question of taking the statutory definition of development and applying it to the facts of the factual record, which, as Mr. Vesely pointed out, included this lengthy submission by the petitioners alleging, factually these things, constituted building activity. And it's this type of factual determination that, as the court recognized, does not undertake on second tier. And again, what the circuit court had before it was a factual record of petitioners' activities, all of which were these planning activities prior to engaging in any building activity. And this was the clear discussion as referenced in the city council hearing transcript. The actual definition says the carrying out of any building activity. And petitioners don't like that definition, so they try to use other phrases not found in the statutes and definitions that don't apply to justify how their planning and designing and negotiating could somehow satisfy it. And if the court will notice, the petitioners repeatedly in their briefs use the phrase development activity, which is purposefully more broad and vague sounding, but it's not what the statute says, which is development activity. And they bring up Black's Law Dictionary and cases concerning common usage, and those just are not applicable, because we're dealing with a governing statutory definition, which again, here on second tier certiorari, at the end of the day, this is asking the court to say that the circuit court got it wrong. Or worse, it's asking it's asking this court on second tier certiorari to say, you should apply the facts that I'm telling you about to the statutory definition differently. And it's just not something that happens here. And to conclude, it's the same thing. And I know this wasn't addressed in petitioner's opening argument, but the estoppel argument or the delay argument, it rests on these assertions in the petition that the city, purposefully delayed processing their building permit applications. And it's a fact question that was not developed below, could not be decided here on second tier. And I'd just like to point out in my closing couple of minutes here that even if somehow the court were to go to beyond it, I mean, it's also very much contradicted by the record. The petitioner repeatedly asserts that it submitted its building permit and submitted everything on January 18th, 2019. And the record just refutes that. I mean, it wasn't even developed everything that was required, but what the record does reflect, and this is at Appendix 100 and Appendix 57, on February 15th, which was 4 business days before the site development plan expired, is when the petitioners first submitted the permit that would allow them to access the construction site. And the emails that came later on March 5th and 6th, acknowledged that there were several other things that were missing. So, I mean, I even hesitated to mention that because, again, just this delving into the factual record is not something that the court does on second tier. And with that, I would ask the court to thank the court for its time and ask it to please deny the petition.
Very good. Thank you, Mr. Rosengarten. Mr. Vesely?
Thank you, Your Honor. Point of order, did I actually use all 16, 17 minutes of my initial? Because it feels like I didn't. Is that?
You did.
I did?
You
Okay.
did, but I'm giving you, you actually went to,
All
I think
right.
it was
Well, I appreciate
17
that, Your
something,
Honor.
but
I
you've got
appreciate
the
that very
4
much.
minutes.
Okay. Your Honors, we're not asking for de novo review. We're not asking for you to just look simply at the evidence and transcript that exists in the record. We're asking you to hold up this final order denying petition for writ of certiorari to that record and show that this court, that the trial court did not meet its burden and fulfill its responsibilities. It talks about in this one concluding paragraph that the city accorded procedural due process, but it doesn't say how it reached that determination. And it talks about that there was competent substantial evidence. Of course, the record doesn't reflect that either. But as to prong two, okay, the court in prong two, in first tier is whether the essential requirements of law have been observed. The court just focuses on this one statute and says, that even if the court, and they're focusing only on one issue, and that issue is whether there was written findings. And I believe that's a huge, written ruling, if you will, a huge failure on behalf of the city council. But he's focusing on this one statute. He doesn't look at the case law. Contrary to what my opponent says, I do believe that it is required that they do have some type of a written ruling, because otherwise you really don't have the opportunity to understand what the basis of that ruling was and review it on appeal. That's the whole point of the first tier, is to have a review on appeal. So by him just sloughing it off on that section 166 might or might not apply, but regardless, it's harmless error, the court hasn't done its job. I know he talks about this is our fourth bite at the apple. Well, we really haven't had any bites at the apple until now. Because the court didn't give us what it was required to give us. And that is a consideration of what actually happened at the city council level. Your Honors, the decision by the circuit court, it doesn't reflect what actually happened at the city council level. Okay. And I believe this court needs to, going forward, submit an order that sends it back to the city council for a proper review based on, a proper appellate procedure, and allow the city council to actually issue an order that is based on the proper procedure, not have all of this evidence presented by city councilmen and by the attorney that's not even part of the record below. And then in the course of doing that, this court can write a primer on how city councils are going to conduct appellate proceedings in the future. The fact that they need to give a written order that can be held up and reviewed by the trial court on first tier certiorari is a no-brainer. They have to submit something that shows what they did. All we have is 3 nays and 3 yays. It could have gone either way. They didn't have a complete discussion over anything. It was very clear from the record in the city council level that they didn't agree on what these statutes meant. So, they need to write an opinion if they're going to have a dissent that says, no, I think it means this, just like an appellate court does, but they don't have that. And so this court is looking at what the trial court did on first tier cert, and the trial court I don't think it did what it was doing either. I think the trial court needed to go in, hold them to a higher standard, and do it and make them give an appellate decision appropriately, but it didn't. It said it's harmless error. We see the record. We're good. Thank you very much. So, Your Honor, again,
that was the end of the 4 minutes, but you can take 15 seconds if you want to conclude.
Well, I want to thank you all for listening to our argument here. I'm hoping that the court will send it back for an opportunity to go back before the city council on appropriate procedure.
Very good. Thank you, Mr. Vesely, Mr. Rosengarten. We're going to take a 10-minute recess, and just in case the participants in the last case were not on at the time we had a switch in the docket, we will resume with Bain Complete Wellness versus Garrison Property and Casualty And then we will do the last case, Pellegrino versus Department of Revenue. Again, a 10-minute recess. Thank you all.
Thank you.
All right, as soon as Judge Atkinson is back on, we will be ready to proceed. There he is, Judge Atkinson, Judge Smith, I see both of you. So let's go ahead with the case that we passed over a little while ago, Bain Complete Wellness versus Garrison Property and Casualty. Very good. I see Mr. Dutton and Mr. Jackman. It appears you are in the courtroom, but I don't have your video or audio. There we go, Mr. Jackman. All right, we are ready to proceed. Mr. Jackman, the floor is yours.
May it please the court, my name is Xavier Jackman. I represent Bain Complete Wellness in this matter. And at this time, I'd like to reserve the full 5 minutes for rebuttal.
Very good.
Members of the court, this is an appeal of an award of sanctions awarded by the lower court pursuant to Florida statute section 57.105. The issue regarding entitlement was that the demand letter set in a PIP case was found to be insufficient as a matter of law, and that the contents of the demand letter were untenable for legal defense. Therefore, the court found an award of sanctions based upon the demand letter. Further, other issues that I'm going to address today are the evidence presented at the fee hearing, as well as the award of costs pursuant to Florida statute 57.105. One thing I did want to clear up prior to beginning was on my standard of review on my brief. I argued that it was a de novo standard. I believe that to be correct for a majority of the issues on appeal. However, when I was looking at this, I do want to clarify with the court that it is an abuse of discretion standard when it comes to award of fees and amount of hours. I apologize for misstating that in my brief. But going on to the standard of section for sanctions pursuant to Florida statute section 57.105 was recently espoused by your honors, Judge Silverman and Judge Smith in the Schur versus Silverio. I'm not exactly sure the pronunciation of that. In that decision, your honors stated, we recognize, however, that section 57.105 must be applied with restraint to ensure that it serves its intended purpose of discouraging baseless claims without casting a chilling effect on the use of the courts. They further went on to cite the 4th DCA case of Minto versus 1,000 Friends. And it says, when there is an arguable basis in law and fact for a party's claim, a trial court may not sanction that party pursuant to Florida statute section 57.105. Again, as you're probably well aware, Judge Silverman, you wrote that order, and Judge Smith, you concurred. When we look at the basis that was stated for the sanctions in this matter, there are basically 3 or 4. It was a little confusing with the writing of the motions and the orders, but the initial one seemed to be that $10,000 was the most that could ever be sought in a PIP demand letter. That is a misinterpretation of Florida statute 627-736 subsection 13, which provides a minimum benefit coverage. It does not provide a maximum benefit coverage. To quote, if the Financial Services Commission determines that the cost savings under personal injury protection insurance benefits paid by insurers have been realized due to the provisions of this act, prior legislative reforms or other factors, the commission may increase the minimum $10,000 benefit coverage requirement. And so the argument—
What about the policy? What about the policy cap?
The policy in this case actually did limit benefits to $10,000 of PIP benefits, and there was no med pay. However, we didn't find that out until a day before the hearing on the motion for sanctions when that document was finally filed with the court.
I thought you were
this,
provided with documents that would put you and your client on notice of that.
there is no certified copy of the policy that was ever filed with the court. And then what they cite to in the record is a response or a response to request to produce. But the record shows exactly what was filed. It was the written document, but the documents that were supposedly attached were not attached. And if you look at the record, you'll see that they cite, when they say that the document was in fact produced prior, they cite to the record, but the record shows that only written answers were provided and no documents were filed with the court.
Mr. Jackman, let me just follow up on that quickly, because having done some litigation myself, I kind of know how the discovery itself isn't filed in the record. But if there is some claim that the actual policy was served separately to counsel with the physical or electronic copy of the responses to the request to produce, was there anything in the record to that effect?
I don't have anything. I reviewed my records, Your Honor, and I went through to see if I had any documents attached. And my records do not show that any documents.
Well, hold on. I don't want to know. I don't want to know anything outside the record, because we're confined to the record. So, yes. Okay. So was there, and this kind of goes either way. Was there any record evidence that that you had it or that you didn't have it? And if there's not, there's none either way. I'm sorry, I don't mean to interrupt.
No,
I think it's an important fact to know whether there was any record evidence that you had a physical copy of it, separate, of course, from the record.
I don't believe I did on this particular policy. I do have USAA and Garrison policies that I've received in different cases that I could utilize to determine that I knew the basis of the terms and conditions of their policy. As for the declarations, there's
Garrison never put you on notice that the policy cap was $10,000 prior to you said the eve of the.
They made allegations. They made allegations, Your Honor, but they never provided any record evidence that the policy was in fact 10,000. No, it was not. The policy was not filed with the court until the day before the hearing on the sanctions.
Well, we just covered that, and Judge Smith was just drawing a distinction between what was filed with the court and what evidence might be in the record indicating that you or your client were made aware by the defendant that the policy cap was $10,000.
The only thing in these, anything that would happen after the sending of the demand letter. Remember, we have to look at this at the time the demand was sent. And I think it's important to remember that we have rural metro out there that tells us that a first party a medical provider cannot get information, policy information from a first party insured.
What if the defendant is happy to make you aware of policy information for the purpose of showing that your demand letter, well, and their argument is insufficient under the statute, but is also illustrative of the paucity of the merits of your claim, so to speak?
I asked for a copy of the policy in the demand letter, and they refused to provide it.
Mr. Jackman, I wanted to follow up on something you just said, because I think it's important when we're looking at this. So there's a safe harbor period of 21 days, right, after the motion is filed, and that safe harbor period closes. And if you take action, you take action. If not, then you risk if later down the road it's determined. And so when we are looking at this from the standpoint of what was known or should have known at the time, we're looking at it from the standpoint of December 1st, 2016, when the motion for sanctions was filed.
Correct.
Okay. And so if I look at that from that standpoint, then I have to look at what was in the record before. And I think there's the motion for summary judgment was already filed. The affidavit was already filed along with that. And then I guess some requests, the responses to the request to produce. In that, was there any facts about what the policy minimum or maximum or the deck, like detailed facts, not the actual document, but was there any responses that would have put you on notice at that point in time?
There was an allegation contained in Mr. Briggs's affidavit that there was a policy, and that the policy terms and conditions were what they were, and that had been previously filed with the court. It had not been previously filed with the court. He referenced a document that didn't exist. And so I don't believe that to be sufficient to establish as a matter of law, to the disregard of any tenable argument, that there was $10,000 coverage available. And even if there was, go ahead, I'm sorry, go ahead.
No, my next question is, as far as the actual, the proper insurer in this case, there's some, I guess, USAA and Garrison, even though you're getting items from USAA and USAA is giving the payments, the insurance company is actually not USAA who issued the policy, but it's Garrison. So at that point in time, was there, or later, was there any effort to rectify the demand, the pre-suit demand with the correct insurance company?
Well, if you read the response to the demand letter, and I believe that's records 133 and 134, it's the last two pages of Mr. Briggs's affidavit, he responds on USAA letterhead.
Right.
And in that letterhead, he said USAA made payments. And so there becomes a dichotomy, because we have them saying it's not the right insurance company, yet USAA is the one that made payments. And so, and the letters on USAA letterhead, all the EOBs are on USAA letterhead, and they're saying that USAA is the company that made payments. And I think that was really the line that raised the eyebrow.
In that letter, do they disclose who the insurer is?
They say Garrison was the insurer, but then they say USAA made payment. So there's an ambiguity there, specifically regarding who they're claiming. Is there really a differentiation, or is this just the same company putting on a different hat? And I think there's case law out there regarding that. I believe I cited in my initial brief. I may not have. I don't know off the top of my head, but clearly,
I guess,
Mr.
are you
Briggs,
looking at, I'm trying to think, you're looking at which page of the record?
And when we're looking at the response to the demand letter, it's 133 and 134. It's the last two pages of the Briggs affidavit.
Okay, because the only thing that I see in that where they talk about the insurer is that they say the name of the correct insurer is listed on the insured's insurance card on the right up, or the upper left-hand corner. I don't know that they actually state Garrison.
Give me one sec. Yeah, there you go. Yes. So USA, but they say USAA made payment.
Okay. I just was trying to figure out if they had given you notice prior to the December 1st motion for sanctions that the insurer was actually Garrison and not USAA.
Anything would be contained in the demand response. There was no other communications regarding this claim that I'm aware of.
Okay,
Let
thank
me
you.
ask you this. So you mean Bain files a demand letter, wants to sue the insurer. Now, Bain is not in privity with either Garrison or USAA, right? Bain is an assignee of benefits of the insured. Should we presume that at all stages, it's the insurer's responsibility to inform you of what your assigned rights are? Or is it possible that we could look at it differently and presume that maybe it's the assignee who took assignment of benefits, presumably in lieu of payment? It's that entity's responsibility to know exactly what benefits it was assigned, which would require, or at least potentially be able to be effectuated by asking the assignor to provide a policy to observe, to look at that policy would have told you who the insurer was. That policy would have told you what kind of cap on benefits there might be. Why should it be the insurer's responsibility, who's being sued in a demand letter by a third party, to inform you of what your rights are under your assignment of benefits?
I don't know if they have any responsibility to do it, but I don't think you can hold it against the provider for that information not being, because it's specifically precluded under
what
rural
is
metro.
it, and what is specifically precluded?
Any policy information regarding first party insurer.
Right, you can't demand it of the insurer, but why can't you demand it of the insured with whom you're in contractual privity that includes an assignment of benefits under a contract with a third party? You can't ask the party from whom you were assigned benefits to hey, shoot me a copy of the policy or your insurance card so I even know who the actual insurer is.
I think in certain situations that is possible. It's not going to be possible across the board, and it shouldn't. I don't believe it should be the policy of the state of Florida to require that. Especially
well, no, it's not. That's not a policy of the state of Florida. It's just yeah. We're trying to determine what seems to be at issue here is there's one could perceive of Bain's decisions with regard to their demand letter and going forward with the suit as either, I mean, I'm just going to be frank here, intentionally obtuse, or one could think, well, they were being kept in the dark by an insurer who didn't want to provide enough information, or let's say perhaps a factor in determining whether of those two instances were the actual case, intentionally obtuse, being kept in the dark. One could think of the facts and one could draw reasonable inferences that if a party, in lieu of payment, accepts assignment of benefits, that party would probably have an interest in knowing what benefits it was assigned. And they could get that from the assignor just as easily as they could get that from the third party contracting party.
A couple of things, Your Honor. Once we got the assignment, we did request the insurance policy, and it was denied. Secondly,
denied by whom? Bain?
By
your
the
client?
The
insured?
The insurer. The insured.
Well, why didn't you ask for the policy from the insured?
We did not ask for the policy from the insured. It's the purpose of the PIP statute is a swift and virtually automatic payment. The most efficient method to get this policy is through the insurer. You take the assignment, you believe you have all rights and privileges that the insured had, but yet when you go and request the copy of the policy, they say, no, we're not going to give it to you because you're a first party medical provider and we stand on rural metro. So they kind of have it both ways. They say, without an assignment, we don't give it to you for rural metro, but then you have an assignment and they still fall back to rural metro. So it does provide some problems. Number two, there's situations where there's omnibus insurance. I mean, there's people that, especially with PIP, I mean, you don't even need to be in the car. You don't even need to know this person to have that policy cover you for a loss. It just needs to be related to the use and maintenance of an automobile. So if you get hit on the side of the road in a bicycle, you are going to recover PIP through the driver's policy. And so the idea that person who's sitting in a hospital with multiple broken bones is going to be able to garner that information, whether even if I'm not quite sure for an omnibus insured, even if they would have privy to that information. So,
Mr. Jackman, let me just let you know you've gone beyond the 5 minutes. If you want to reserve your 5 for rebuttal, I'll go ahead and let you do that.
Yeah, I'll just take a couple minutes, Your Honor, if I could just move on real quick.
Yep.
I think you guys saw when if the court determines that the award was justified, when we got to the fee hearing, I never got time slips, despite us repeatedly requesting them. Again, much like the policy, it was provided the day before the hearing. Mr. Dutton apparently at the hearing tried to claim that the affidavit of the expert served as producing time slips. That I don't believe is sufficient. The expert specifically stated that he got some information from Mr. Dutton. He copied and pasted it into a new document, and that was the document that was provided to us. Obviously, that doesn't satisfy the requirement of providing the time slips prior to fee hearing. There was a summary of the time slips used by Mr. Dutton. There was no announcement that a summary is going to be used. And like I said, the time slips were never produced. As such, the summary should not be accepted as evidence. Real quick, there was some cases that were entered into evidence. There was no motion for judicial notice made for these cases. They were all entered into evidence. I made motions for judicial notice for cases from the court that were apparently excluded. So I'll just reserve the rest of my time for rebuttal.
Very good. Mr. Jackman, you'll have 3 minutes for rebuttal. Mr. Dutton, you may proceed.
Thank you, Your Honor. And because the court was concerned about it, my name is Scott Dutton. I represent Garrison. And so let me sort of build this from the ground up, particularly regarding the court's concern, and particularly yours, Judge Smith, about what they knew or when they knew it. Let's start with the response to the pre-suit demand. And so we sort of jumped over exactly what's on the face of 133. So let me tell you that letter in response to the pre-suit demand that he's talking about was part of the affidavit served by the claims adjuster in the case, Mr. Briggs. And it is Exhibit D. And what it says, and let me read it to the court if I may. Number one, the correspondence is invalid because it has identified an insurer that did not issue the insurance contract. The name of the correct insurer is listed on the insured's insurance card and on the upper left-hand corner of the explanation of reimbursement. Now, part of that affidavit, all the way through, are the explanations of reimbursement, multiple ones. And if you go to any one of them, let's say for record 123, up in the upper left-hand corner, just like it told Bain, look, and it says company, Garrison Property and Casualty Insurance Company. And that's because USAA is just a logo. It's not a company. In fact, the only thing that would be even close to it would be United Services Automobile Association, which is an insurance reciprocal. It's not even a company. But be that as it may, they're told that to look at the insurance card. Now, we're not going to dive into what sort of information that Bain receives as the provider each time it sees a new patient. But one of the things they normally see is the insurance card that says who the insurer is and also what the policy is.
Let me ask you this, Mr. Dutton. The as far as any payments that Bain received, were those issued by USAA?
They're issued by Garrison. They're all different risk pools. And if the drafts were here, part of the record.
Well, let me
Garrison on it.
Okay, so yeah, let me ask it this way, because I think I'm correct that I have to be looking at, and we have to be looking at December 1st, 2016 at when the motion was filed, not later.
Actually, there is a later date. There's also, I believe it's April of 2017, but we can come back to it, Your Honor. I interrupted you. My apologies.
Okay. What is the later date? Was there a second motion?
April 11, 2017.
That's right. Okay.
That's the actual date that I believe the court traveled upon as well, that particular date.
Okay. And that's the second motion. So I'm looking at the EORs and I'm trying to match these up with the PIP log, that the ledger that was done. So if I add up all the PIP allocated line items and I add those up, I don't come to the 10,000 on the PIP log. And so my question is, you know, in the course of discovery, parties aren't supposed to just accept what the other party provides them, but perhaps maybe educate me. Am I wrong in that the calculations don't match?
I think if you look at Exhibit B, which page 126 of the record, and the payment ledger and amount at the bottom, says 10,000. And that would be real important, quite frankly, if we were here on the benefits exhausted, which his case had benefits exhausted as well. And that's why the Briggs affidavit is there.
Okay, but see, you're highlighting my point, I guess, which is that payment ledger is from, I don't know, is it from USAA or is it from Garrison? One of the two.
It's from Garrison. It
okay.
only be from Garrison. Garrison
Okay.
didn't insure this person.
But,
I mean, USA didn't insure this person.
Sure, but the EORs that are attached to the affidavit, if I calculate, there's a line item that says PIP allocated. If I add all of those up, I don't get anywhere close to the 10,000 on the payment ledger. And so I want to be very careful in looking at this as to what they knew. So shouldn't those match?
No. And because they're not, I don't believe they're each and every single service provider. But again, if we were here in a exhaustion case and following the court's point, but as it relates to what the correct insurer is in this case, every single explanation of review shows the correct insurer in the upper left-hand corner.
Well, you're also talking about the cap, and you digress back to the name of the insurer. I can't speak for Judge Smith, but I think one of the things she's getting at is that one of the arguments that the demand letter was insufficient is that are the numbers. You know, in other words, it was a $30,000 demand, and so does it matter that whether there was exhaustion if the demand exceeded the $10,000 cap?
Yes. The reason is because you can't, no matter what, you can't. I should have started with, this is a PIP case. And despite there may be some exception to it that was alluded to by Attorney Jack, nevertheless, PIP only has $10,000 in coverage. You may have some other types of coverage that may be available, which was not available here, but it wouldn't be under PIP coverage. You can only get $10,000 in PIP coverage. In fact, if I may, returning back to that response letter, page 133, Mr. Briggs goes on to explain, please be advised that USAA has paid a total of $10,000 in benefits and that the personal injury protection benefits for this patient they claim have been exhausted. So it tells them what the policy limits is there, but it also tells them in the affidavit itself. And if you look at the affidavit of
Mr. Dutton, well, one, it is a little, I have to admit, it's a little confusing for you to say that USAA is just a logo, but in the letter and the response to the demand, they're advising them that USAA has paid all the payments, which you just told me Garrison did. So I'm a bit confused. But then to my other point, which, you know, is concerning to me, is that if, you know, litigants aren't supposed to necessarily take the other side's documents at face value and say, oh, you say it's this, therefore, you know, I don't need to do any discovery. And at this point in time, can you tell me in the record, was the other side provided with a certified copy of the policy that would have showed these limits?
That was going to be the second point I was making. But before I just leave this packet of Mr. Briggs, I did want to point out that in the front, there's the payment ledger, page 141, but more importantly, the second document, look at the record page 142. There's a declarations page. And the declarations page is the declaration of coverage. In the upper left-hand corner where it says Garrison Property and Casualty Insurance Company. And then on down, it actually talks about the specific policy limits for personal injury protection. I did want to underscore that because it lists the $10,000 there, again, on page 142 of the record. But
so we're all straight. So when was that provided to the plaintiff?
November 18, 2016. USA was doing everything it could to tell Bain, you need to dismiss this case. You need to dismiss it because benefits are exhausted. And later you need to dismiss it. It's in the affirmative defenses. You need to dismiss this because you haven't named the right insurer and that your pre-suit demand exceeds the available policy limits. But I do want to get to the point that you made, Judge Smith, and that is in the response to request to produce. And if you would look specifically at page 56 of the record, you will see question or request, a certified copy of the insurance policy, including all applicable endorsements, the complete application and declarations page that was issued by the defendant, which affords coverage and has been claimed by plaintiff to afford coverage to Carrie McDougall. Response, a certified copy of the policy and declarations is attached.
But it didn't make it in the record in that attachment because I didn't see it to the back of that.
It wouldn't, because obviously it would be, if you will, when we produce documents, as the courts are alluded to, you did litigation.
Well, and we would put that a separate copy is being served via a separate manner, not that it was actually attached. So, I mean, there was probably a better way to have said that.
Yeah, and so what normally happens these days is that it's served this electronic copy in the response to request produced, and the actual documents that are going to be provided are provided in separate form. That's normally how it's done. In this case, it was done. And if it wasn't done, that is never, ever in any of the motion practice that we didn't receive the policy that you say we received in the response to request to produce. That's not part of any motion practice here before the court. Moreover, and again, I do want to circle back to the affidavit of Mr. Briggs for not only that reason, but in his affidavit, Mr. Briggs specifically states that the policy has only $10,000 worth of coverage, of PIP coverage, and that is also significant as it relates to this particular matter. So we're looking at several times over where they're told, they're shown before the suit is filed, they're shown when suit is filed by the vis-a-vis the POBs, vis-a-vis the certified copy of the policy.
You filed two. Sorry to interrupt you, but we actually let me let you finish because this has been a point of contention. So please finish. Go ahead.
No. So on multiple occasions, long before the motion for sanctions was filed as it relates to the invalid pre-suit demand, they were put on notice of they served it against the wrong insurer because the statute specifically requires a couple of things. Number one, must be provided to the insurer, and USAA, despite the fact it's local, is not an insurer. But number two, that they were advised that it was the wrong insurer. And then it gets to specify the amount claimed to be due. And this is a PIP claim. Again, it's not a claim for.
Let me ask you this. So let me interject then my point here. You filed two motions for sanctions, or you at least started two grounds, right? One was that this two arguments, and perhaps two motions, I forget, but that maybe that's what y'all were talking about earlier, two motions, but two arguments for why the claim was not supported by the merits by the law or the facts. Now, one of the arguments is that the condition precedent of a demand letter was insufficient. The other one was that the claim itself lacked merit, correct? I mean, in other words, there was no one, you could not have been possibly entitled to what they were what they were seeking.
It's a $10,000 right? Yes, sir.
And, yeah. In fact, so in other words, so before we get to that latter, that other ground for 57105-1 sanctions, let's talk about the ground that it seems the court latched onto and asserted as the basis. Now, the demand letter, was the demand letter insufficient? So the demand letter says, the statute says you need to itemize this, an itemized statement specifying each exact amount, the data treatment, service, and accommodation, the type of benefit claim to do. You know, the purpose is to put you on notice of what they're demanding. They could say, you know, I want $1 million in, massage therapy. I'm a massage therapist. I was assigned benefits, and I was assigned the benefits of the insurance policy, and I provided this, this insured with $1 million worth of massages. Now, doesn't that satisfy the notice? I mean, you're on notice. The type of benefit claim to be due. I'm claiming that I'm claiming PIP benefits for $1 million. That may not be meritorious, but based on your argument that the condition precedent hasn't been satisfied, why is that argument prevailing if you're fully on notice? I itemized all the times that the insured came in to get a massage, and it added up to $1 million. That's what I want.
And so let me say, with all due respect, it's been repeatedly addressed by the appellate courts to include, before the second district was taking appeals of PIP cases directly from the trial courts. There was an appellate case directly from the 13th Judicial Circuit. And it addressed that when you're submitting a pre-suit demand, that there is strict compliance with the statute. And when the strict compliance with the statute requires the specificity of the final amount claimed to be due, quoting, and I'm looking at Chambers Medical Group as assignee of St. Hilaire versus Progressive. It's at 14 FLW sub 207. And it's an old case from the 13th Judicial Circuit appellate from 2006. That says, we conclude that strict compliance with the notice requirement is required to effectuate the purpose of the statute. And what it's talking about specifically is that they have to enumerate the final compliance. And it says inaccurate, misleading, illegible, or stale information contained in a demand does not strictly comply with the statutory requirements. That was also addressed by the 4th District Court of Appeal in a case called MRI Associates of America LLC versus State Farm back in 2011. That's 61 Southern 3rd 462. And I'm going to go to the next case after that, which wasn't there at the time, but the 3rd districts looked exactly at this issue, and that is what specificity is required. And when the 3rd district looked at it, this is the case of Rivera versus State Farm Mutual Automobile Insurance Company. It's 317 Southern 3rd 197 from February of 2021, and we quote from it extensively. It talks about the precision that's required in the demand letter to itemize, specify the exact amount claimed to be due. So it disallows them to just put anything in there. It wouldn't.
Does it allow? I don't think you're answering my question. Actually, does it allow them to list the specific amount claimed to be due? And if your only argument that the demand letter is insufficient under the statute is that you don't believe that under the policy or under the statutes governing PIP policies that amount is that the insurance company is liable for that amount, how does that fail to satisfy even what you just described from those cases, that the specific amount claimed to be due, to quote the statute, has been set forth in the demand letter?
Well, this is what the statute says. It says that notice must state that it is demand letter under 627.736 and state with specificity. Then it goes down and says an itemized statement specifying each exact amount. And then it goes on to talk about the date of treatment, service, or accommodation, and the type of benefit claimed to be due. That would open up that would defeat the purpose of the pre-suit demand statute because it completely lacks the specificity as required by.
Let me understand your argument though, and the argument that was convincing to the trial court about the insufficiency of the demand letter. My understanding of the argument, and you can tell me whether at present I'm forgetting other aspects of your argument, which is totally possible, but it is that because the policy, presuming the policy was capped at $10,000, that it cannot possibly be the case that the insurer is liable for the approximately $30,000 claim to be due.
And that's
is there any other argument as to why that the demand letter does not satisfy the specificity requirement?
Yes, they also attach the billing ledger to it. And that if you look at the billing ledger is itself intrinsically inconsistent with the amount that they put in the demand as claiming to be due.
Yeah, okay. So in other words, I said, well, we want $1 million in massage services, and their billing ledger, didn't add up to $1 million.
No,
so that somehow doesn't specifically specify an exact amount that they claim to be due. The attached documentation.
But 2 points to that, Judge Atkinson. Number one is it also exceeds $10,000. And number two is, and all of the appellate case law on this, it leads to a misleading result. It also doesn't take into consideration something Judge Smith pointed out earlier, is all the payments that were given to Bain, which the appellate case law also says it has to take into those considerations. So the point is that the purpose of the pre-suit demand statute is to put an insurer on, if you will, a last chance notice to pay the amount that is. So
let me ask you that. I know the purpose that's stated in the case law. Aren't you on notice if a plaintiff assignee says, I gave $1 million worth of massages and I think I'm entitled to every penny of it? Aren't you sufficiently on notice about whether to pay that or whether to go to trial? I know what you're seeking. You said it specifically, and maybe your documentation adds up to 990,000, and you're missing, a bunch of receipts, or the payment ledgers. It doesn't comport with the amount demanded. But you're on notice. You said, well, you're seeking what appears to us as the insurance company to be a frivolous claim. We're not liable, so we're on notice. We can decide we're going to defend. We're not going to pay.
And again, it's not the amount.
Before you answer, Mr. Dutton,
it's not the amount. Go ahead. I'm sorry.
Before you answer, we're at the end of your time, but go ahead and answer the question. Absent more questions by the panel, we'll turn it back over to Mr. Jackman, but go ahead.
And Judge Atkins, you bring up a great point about litigation. The purpose of the pre-suit demand statute is specifically to avoid litigation, to give the insurer that last chance in order to pay a specified amount which is actually due. And so I guess I should have pointed that out, which is actually due under the law. And in this case, $35,000, or if you look at the letter, $27,000 is not due under the law. And with that, I certainly want to appreciate that and ask the court to affirm the court, and that these cases cannot continue to be brought when there's only $10,000 of PIP benefits and the pre-suit demand doesn't specify and doesn't provide the exact amount due, Your Honors. Thank you so much.
Very good. Thank you, Mr. Dutton. Mr. Jackman, I had you down for 3 minutes, but I'll give you an extra one. So you've got 4 minutes for your rebuttal.
Mr. Jackman, real quick, could you just answer me with something really quickly, and then I'll and now that I've already derived your thought, there were two grounds listed. They're asserted. Now the trial court based its 57105 entitlement finding on the ground that the pre-suit demand letter was insufficient. There was an asserted ground, which is that not only was your pre-suit demand letter deficient, but your whole case is deficient. And you were served with a motion that said that's also grounds that your entire case, even if your pre-suit demand letter was sufficient, your case is not supported by the law and the facts. Could we affirm based on that as a tipsy coachman argument?
You could, as a tipsy coachman argument. It's not true. The case, the pleading was fine. It identified the provider. It identified the dates of service. It identified bills that were sent. It's identified that the bills weren't paid as sent. And like the prime
at the time you were served with the 57105 motion that said your actual cause of action is not supported by the law and the facts. Could we infer that at that time you knew that even if the demand letter was just fine and dandy, that there was no entitlement to anything over $10,000, and that perhaps that $10,000 itself was extinguished by payments?
I think we need to get a quick little procedural history real quick. We talk about this affidavit of Dennis Briggs. I tried to set his deposition, and they refused to show up. And then they filed a motion for protective order, and I was never allowed to even talk to Mr. Briggs. And so we're relying on this affidavit, and I was never allowed to cross that affidavit. They made, we had a hearing regarding the protective order. The judge said we could go ahead with the demand letter without any depositions or any further discovery regarding Mr. Briggs. But if we wanted to talk about that $10,000, they'd have to sit him for deposition. So I don't know if that answers your question. Is that what you were looking for? I mean, I'm trying to.
And you voluntarily dismissed.
I voluntarily dismissed when we got the policy. As soon as we got the certified copy of the policy, we dismissed.
Mr. Jackman,
I
want to ask one question that has been puzzling me. The demand letter was in a significant amount over $10,000. The actual complaint that was filed, and the trial court noted this in the order, the complaint is undue and overdue personal injury PIP benefits and interest in an amount less than $99. That's a pretty big discrepancy from the demand letter as well.
Correct.
So how do you explain that?
It's the demand process working, Your Honor. It is us identifying that there's issues that preclude us recovering the full 36. The full 36, the reasons it's demanded is because both medical payment coverage and PIP coverage both require a demand letter. It's in the insurer's best interest that we include this all in one demand letter so they don't pay PIP and not pay med pay, because it goes to person C for med pay and person B for PIP, and it creates a confession of judgment situation. So you include both, and that's what, if you look at the demand letter, it's a demand for PIP and med pay, because we don't know if there's med pay coverage, because like I said earlier regarding rural metro and the difficulties receiving this information prior to getting your demand out. Real quick, Mr. Dutton said payments were made by Garrison. There's absolutely nothing in the record regarding that. MRI Associates does not stand for strict compliance. It's actually, the language is very clear. It talks about substantial compliance. I'll quote from that case. The claim, first it refers to how the claim must be submitted. It says the claim must be submitted on a standardized form, properly completed pursuant to Florida Statute 627, 736, 5D. Isn't it? An insured is not required to pay the bill. I'm sorry, go ahead.
Yeah, Mr. Jackman, let me ask you, as far as the statute, does the statute, what documentary evidence does the statute require that you submit with the pre-suit demand?
With the assignment of benefits and a ledger or other document identifying the treatment, the amount charged for the treatment, the date of the treatment, and the provider.
Okay.
Mr. Jackman, we're at the end of the time. Take 15 seconds with your conclusion, please.
Thank you, Your Honor. Again, we're here on a motion for sanctions. We've had lively debate about the propriety of this demand letter. We've had arguments on both sides. My argument is not that the demand letter was sufficient, only that my arguments regarding the demand letter were tenable. We're not here to determine whether the demand letter is sufficient or not. The question presented to the court is whether or not my arguments were so devoid of law and fact that they were non-meritorious. I believe the Schur versus Severio cases that two of you were on would I certainly have raised at the very least a tenuous claim. I believe personally that the demand letter is fine. But certainly the arguments presented throughout this entire litigation are valid legal arguments. They're not made up. They're not frivolous. They're based on fact. They're based on confusion. They're based on the information that we had available to us at the time. And I would respectfully request the court overturn the amount of sanctions. And thank you guys for your time. My first time doing this, so I appreciate you guys. If there's anything further from me, let me know.
Very good. Thank you, Mr. Jackman, and thank you, Mr. Dutton. The final case on the docket is the Pellegrino versus Department of Revenue case. Mr. Pellegrino, Ms. Bernstein, I see you are both in the courtroom. You need to turn your video cameras on if you are using video today. Thank you, Mr. Pellegrino. Ms. Bernstein, are you with us? You're on mute, Ms. Bernstein, if you're trying to respond and your video is still not on. There we go. All right, thank you, Ms. Bernstein. Mr. Pellegrino, we're ready. You may proceed.
Good morning, Your Honors, Judge Silberman, Judge Smith, and Judge Atkinson. May it please the court, my name is Paul Pellegrino. I am the appellant, and I will be representing myself today because I have to. This case directly affects my integrity in the eyes of my only daughter, Gianna, who is 17. I will remain cognizant of my time allotment, and I respectfully ask for the 5-minute rebuttal.
Very good, Mr. Pellegrino. I'll let you know when you get to that point.
Thank you, sir. This entire case centers around the mutually agreed to child support contract that Stacy Lang and I entered into during October of 18. It was absolutely designed with the best interest of our daughter in mind. Like Mr. Jackman said earlier, this is my first time ever doing this. So please allow me 2 to 3 minutes just to provide a clear picture and a logical pathway before I jump into the index of records, please. This case is rather simple. There are only 3 issues. On November 5th of 19, that's the day I finalized prepaying child support to the appellee for $19,000. In return, the mother agreed to waive all remaining child support payments through her high school graduation in June of 2023. Second, on November 30th of 20, the appellee contacts the Department of Revenue and falsely accuses me of not paying her during the time period of May 1st, 19 through June 30th of 2021. And lastly, Department of Revenue never once questioned the appellee's accusation or motivation in this case. Please let me assure this court, I am not here objecting to financially taking care of my daughter. I always have, I always will. She is the reason I agreed to move to Florida with her mother, so that we can provide her a better lifestyle and that she could attend high school and college here in Florida. At 65 and retired, she's the #1 priority in my life. I am here, however, objecting to this FASO, as well as the Department of Revenue labeling me as an irresponsible father, a convicted deadbeat, and believing that they know what's better for my daughter than I do. And that's unequivocally not true. If you have children, put yourself in my place. This is very personal to me. It is not a job assignment. I say convicted because the Department of Revenue in February levied $13,000 from my bank account, knowing very well that, okay, today's hearing was pending. There are 4 major turning points to this case: probable perjury, administrative oversight on both sides, a jaded FASO, and an unforeseen extenuating circumstance. Before I proceed any further, I'd like to make one concession. I do not have a law degree like everybody else that's present here today. I did invest the time, though, to watch a number of oral arguments previously and to read as much as I could about the rules and procedures of this court. And I have to honestly say, I won't be reciting any case law or any Florida statutes because that's way above my pay grade. I only intend to stay focused on the truth and facts that are on the record as I address a number of the Department of Revenue's arguments. If I cross any boundaries, it is not intentional, but I do respectfully ask for any appropriate leniency since I am the underdog here today. May I please direct your attention to our opening contract labeled Florida Relocation, page 113, where it clearly indicates my promise to perform. If you look or read the contract, it clearly states I would prepay Stacy Lang $20,000 in lieu of Gianna's child support balance through her high school graduations. Payments would be made in 4 installments over the course of 18 months, and you can see the layout. Under her obligation to completely eliminate all future child support payments for me beginning November 1st of 2000.
Pellegrino,
Yes, sir.
That's in the record and we're able to review it and have reviewed it. I do want to have you address something that's on my mind. So there in the record, it shows that you provided the agreement, but we're an appellate court, and our only function is to review whether what we call the lower tribunal, which would be the circuit court or in the instance of an agency like the Department of Revenue, an administrative law judge, or some member of that agency staff, And you've talked a lot in your briefs and a little bit in here about what you believe the department knew or should have known, should have suspected regarding the veracity of the child's mother's statements. But the only forum that the department could use to finally determine who was being truthful and not is a hearing. In other words, you may or may not be, or, I can presume for the sake of our discussion that you're correct that, maybe a reasonable person would have known that the child's mother was not being truthful in what she represented the department. But the department can't just make an off the cuff call and say, well, I think the father is more credible than the mother, or the mother is more credible than the father. I think the documents that have been submitted by both, after, we took a look at them and we think that the father is correct. The only method by which the department can make a final determination that we can review was in a hearing. And their argument, that goes to their argument that you need to address, which is the fact that you didn't request a hearing timely. Does that make sense?
It does, Your Honor, and I'm prepared to answer that. I mean, I can go right to the bottom line. I can save us a lot of time this morning, and it could actually explain all of that in detail if that's where you want me to go.
Well, why don't you go ahead and answer, Mr. Pellegrino, go ahead and answer that, and then you can get back to your argument. But the most important thing to understand as a non-lawyer is your best argument is responding to questions that are posed by the panel, because those are the things that are most concerning to us. So go ahead and address Judge Atkinson's question.
Okay, I absolutely will. Your Honor, it wasn't that I did not, request a hearing. I actually did. And let me show you where. On April 29th, I received a package from April 26th, and it's on the record of page 84, proceeding to establish a support order. Item 4, page 85 says you have 20 days to request a hearing. I did not fail to request a hearing or waive my rights, because on April 30th, they had received a letter I submitted to them, and the letter actually states, I look forward to standing in front of a judge with Stacy Lang. The camp case notes 288 shows a conversation with the Department of Revenue on Monday, May 17th, that I did mean what I wrote. I agreed to proceed and intended to do so, and that I finally received all of the fronts and the backs of the cash checks that the Department of Revenue was looking for. But here's a very unforeseen, unfortunate, extenuating circumstance. That was Monday the 17th. On Tuesday the 18th, I suffered a heart attack. I required emergency open heart surgery. I had triple bypass and was placed in ICU. I was unconscious for 5 days. Okay. And while it's not in the record, okay, what I want to say is I didn't have the opportunity to go forward, although I had all my evidence. Needless to say, I was sent home in June with 35 staples in my chest, and with nurses, therapists, family, and friends around me constantly. I was just grateful to be alive and concentrating on my health, my mental, physical, and emotional stability. Now, it doesn't appear that the Department of Revenue knew that this happened to me, but Stacy Lang did. Did she have any responsibility to present it, to include and let the Department of Revenue know? It doesn't appear so, but unfortunately, the FAFSA went through, and here I am working since last July to try and get a hearing to present my case and all the facts. I hope that answered your question, sir.
Yeah, well, I mean, we're going to hear from the other side about whether a request was made in compliance with the statute. The statute says that the parent from whom support is being sought who fails to file a timely request for hearing shall be, and then that's what I was going to get to. We're here to hear your argument about whether you did or didn't request a hearing timely, and the department will have theirs. But what is a problem is potentially if the Department of Revenue is correct that you didn't file one timely in compliance with the statute, that it says you're deemed to have waived the right to it. In other words, there's nothing that can be done after that. once the timely request has not been filed, you're deemed to have waived the right to a hearing. And then it says the department can render an administrative support order pursuant to paragraph 7B, which lays out, in other words, the department can issue a support order of a final order, just like the hearing officer could have, if the parent fails to timely file a request for a hearing. Does that make sense? So in other words, you're right. I mean, if you did timely in compliance with the statute, file a request for a hearing, then the department would not be permitted to submit what under the statute is that final judgment, so to speak, which is administrative support order. But if you had not, then they themselves, the department, without a hearing officer, which is the equivalent of a judge in the executive branch, they can just issue the order, and they're going to do it based on what they have before them. Well, and so again, what is it? What is the so the opposing party can respond, and we can assess it. You gave us parts of the record on which you believe was evidence of your request for the hearing. One was in the notes of call notes. Is that right?
Yes, sir.
And then the other one was a specific correspondence that you sent to them. What record page is that?
That is page 84.
Okay.
And yes, sir.
Page 84 of the record?
Yes, sir.
Okay, we can definitely look at that.
Mr. Pellegrino, I'm actually looking at it, and that is the notice of proceeding to establish administrative support order.
And it's 85, sir. 85, page 85.
That's still part of that same correspondence from the department to you. Judge
Smith apparently found it on page 110. And it says, I look forward to standing in front of a judge with S. Lang.
Yes, sir. It's a handwritten letter when I sent the contracts, the check again, to show them that I was ready to proceed. I wanted to proceed. But unfortunately, again, because of my circumstance, I mean, I did have, from the date I received the information, I did have 20 days to respond. Unfortunately, I think about on the 18th, 19th day is when I suffered a heart attack. I got shortchanged. You know, and I'm not arguing rules and laws. Okay. Unfortunately, I guess, you know, what I'm arguing against is, you know, everything funnels down to a technicality. And this technicality is the difference, you know, me proving that what I did is the absolute right thing and did pay the child support up front versus me being accused of not paying it and having to pay it again. So that's where this whole thing boils down to. And that's why I'm just trying to lay out all the facts and the information so that you can see what I'm up against.
Anything else you'd like to add before we go to Ms. Bernstein?
Your Honor, it seems, you know, everybody knows the facts, you know, the timeline. Okay, you know where I stand and why this happened to me. Okay, all I'm saying is that I did make the payments, and unfortunately, because of a unfortunate situation or a technicality, I'm being accused that I didn't and asked to pay again. And the person that's going to be impacted the most, unfortunately, is my daughter, Gianna. And that's the end of my argument for now, sir. Thank you.
Very good. Thank you, Mr. Pellegrino, and you'll have your 5 minutes for rebuttal time. Ms. Bernstein, you may proceed.
Your Honors, I'm Tony Bernstein for the Department of Revenue. First, let me clarify, the department never called Mr. Pellegrino a deadbeat or anything like that. They are, under the law, allowed to enforce the child support order while it's up on appeal. So, while he's complaining about a levy the department was within its rights to do. Mr. Pellegrino now is, for the first time, claiming that he asked for a hearing. So let's talk about his April letter. That letter came following his receipt, the service of the notice of proceeding to establish an administrative support order. The clock for requesting an administrative order an administrative hearing hadn't even begun because there was no proposed order entered yet. So when the department received that letter, they contacted Mr. Pellegrino, and this is in the notes, and asked him, are you asking to opt out? And he told them no, because that's what it would have been timely for. It was premature for an administrative hearing because no proposed order had been entered, but it could have been an opt-out. And so the department contacted him to clarify that. And he said no, and the notes show that he said he would wait and see what the proposed order was. The department entered the proposed order. They had advised him time and time again about his right to ask for a hearing, and he didn't ask for it. I am not going to question whether or not Mr. Pellegrino had a heart attack, but there's nothing in the record that he ever contacted the department after even receiving the final order to say, wait, I couldn't have made the hearing. And in fact, the department had even waited an additional week to enter the final order. They gave him more than the 20 days that they were required to allow to see, number one, if he would return a copy of the back of the check, or if he would ask for a hearing, and he never did. So having failed to ask for the hearing, he's waived all the arguments that he's made now for the first time on appeal. So we'd ask that you affirm the order.
Well, could you walk me through this? I do agree with you that it seems that the specific argument based on a specific document Mr. Pellegrino has turned our attention to was not made below, but I think on page 110 of the record, that's dated April 30th. And then page 85 is the letter from the department he had been referring to, which is like you said, it's just starting a proceeding. And what you're saying is that, yes, you're acknowledging that the department did receive that handwritten letter, but that is not the, and he was saying that the correspondence, let's see here.
Judge Atkinson, while you're looking at that, I just want to make certain, Ms. Bernstein, what I'm looking at in terms of what you believe starts the clock is the income deduction order that was entered in, that's at record 180. I'm trying to see the date on it.
Your Honor, are you talking about what starts the clock to ask for a hearing?
Yes, was that the final administrative support order?
Okay, so that would be the proposed order that's sent out. That's when
which one is that in the record? Because I'm looking at the final support order.
Okay, the proposed order is on page 136. That's the copy that went to the mother, but that's what starts the clock under the statute.
So it's the proposed order.
So you have 20 days from the mailing of the proposed order to request a hearing.
Because that was June 3rd, and then it looks like the actual order was entered, or what I'll call the final administrative order was entered June 30th. Is that right?
Final administrative order was entered.
That was 185, did you say? No.
180.
Okay, the final administrative order was
one at 164.
Well, the final administrative order is on the rendering page is on 181. That's the day that so that was June 30th.
Yeah, well, there were several things entered starting at record 164. There looks like about 7 or 8 documents all entered on June 30th. And so the time frame that you want us to focus on is in between June 3rd and June 30th, that there was nothing filed on behalf of Mr. Pellegrino.
Between when the proposed order was entered and was mailed, and that was
there's a proposed order summary sheet dated June 1. Then there's a proposed administrative support order and so forth.
Between that date when it was mailed and when the final order was entered, we received nothing.
So I want to make sure we're all on the same page. Are we talking about the time frame between June 1 or June 3 of 2021 and June 30th of 2021?
All right. The proposed order was mailed out on June 3rd. The final order was entered on June 30th. So he would have had until June 23rd. After the 3rd, he would have had 20 days to request a hearing. At the time that he filed, he had only received the notice. And if you look at the notes on page
85.
No. I'm looking at DOR's notes, sorry. On page 288. It shows that after the department received Mr. Pellegrino's letter, they contacted him and they asked him exactly what he was asking them to do. And he stated that he was only sending information to notify the department that he was not going to pay child support and he was not going to return any documents, which he did not. He did not provide a financial affidavit. He didn't provide a parent information form, which would have shown he could have put down what he paid. He didn't provide return the standard parenting.
Miss Bernstein, let me, this is on, my question is directed to the proposed order that was attached to that April letter. And if we're referring to the proposed order, I realize it's not issued yet, but the language, because under the respondent's notice of rights in paragraph C says, if you disagree with this proposed order, you may ask for a hearing by filing a written request with the deputy at the following address. Your written request must be received no later than 20 days after the issue date of this proposed order. Is that somewhat ambiguous to say here, because the order, it doesn't say it has to be executed or issue, the time period for responding to the written request is simply no later than 20 days after the issue date. So I understand your argument of that it was premature. I'm just wondering, in the notice of rights, what apprises a party that you can't file it early, that it has to be only within the window after the issue date of the order?
I mean, I'll look back at the statute, but the department puts in what the statute requires. The statute requires certain language. And I don't believe that it specifies that, if the right starts when the proposed order begins. I recognize what your argument is, but in looking at the material that was provided to Mr. Pellegrino, if this proposed order is attached and it has this language, I'm trying to, see how it apprised him he had to wait. He couldn't prematurely request a hearing. I'm looking to see exactly what the statute says. It says, the department shall provide a notice of rights with the proposed administrative support order, which notice must inform the parent from whom support is being sought, that the parent from whom support is being sought may, within 20 days after the date of mailing or other service of the proposed administrative support order, request a hearing by filing a written request for hearing in a form and manner specified by the department.
So after the mailing of the proposed support order. Is that?
So notices in several places. So let me see.
Talking about 5C1, the parent from whom support is being sought within 20 days after the date of mailing or other service of the proposed administrative support order and request a hearing.
So that seems, if it's a proposed order, that means it's not issued. Do I have that right?
Yes, it's not a rendered order.
Okay. And so would it be timely now, given that what you've just read?
Under the statute, I don't believe it was timely. I also don't believe that it was intended to be a request for an administrative hearing because the department did contact him and asked him what he intended it to be. There's also notes that he later said that he would wait and see what the proposed order came out with. Now, if you're now questioning that maybe this should be written a little better, I can see where there might be.
Well, I think what you've just pointed out, it doesn't necessarily track the statute.
Well, it also says on the first page, 136, request a hearing by filing a written request within 20 days from the date of this proposed order. I mean, I think that shows that it's looking to go forward from the 20.
Well, but it's still saying proposed from this proposed, and it's proposed here. So anyway, I'm just at least pointing out there might be the language in the notice might be ambiguous. You can certainly argue with me on that point, but.
Well, I mean, Your Honor, in light of what you're pointing out, I might ask the court if you'd relinquish jurisdiction for 30 days for me to discuss this with my client. It wasn't brought up below, so I couldn't address it then. Mr. Pellegrino did not raise any of this. And that may be a way to resolve this.
Well, okay, so what we're looking at is that depends on what we have the authority to do or not do, regardless of whether you say we relinquished jurisdiction to the department.
Yeah, I mean, this is a new argument that's brought up. It wasn't brought up by Mr. Pellegrino. He never made the argument below that he had asked for the hearing. None of this was brought up. I can see where the court's confusion is. It may be better for everybody if you.
Well, let's talk about what the confusion is. Okay, so on there, he sent notice essentially. Let's just talk in the vernacular. He sent notice of that there's a case pending against him. Hey, there's a case. Mother or child is seeking support. What do you want to do about it?
Okay, so but there wasn't a case. I'm sorry, Your Honor, go on.
Well, go ahead. You can describe whatever you want. There was.
No, I'm just saying the department asked him. He also said there was already a child support order. They asked him to produce it. He never did. They were not able to locate a case. The only case that's out there is a civil case where he was then suing the mother, I guess, on a contract theory, which was.
No, what do you want? Whatever you want to call. What do you want to call your Let me go back to the your letter of April 26th, notice of proceeding to establish administrative support order. I don't know what you want to call that. I called it a case, and if you think that's wrong,
you mean an administrative case. I'm sorry.
Yes. So, and then 4 days later, and then we're not talking about the call logs or anything. The respondent, I guess he's not a respondent. Mr. Pellegrino says in a written filing, a letter says, I look forward to standing in front of a judge.
Okay.
And then but that's not all we have in the record, right? We have other things. We have other correspondence or at least communication between the department and Mr. Pellegrino. So, and you have said that had some bearing on whether we should consider that written letter saying I look forward to appearing in front of a judge as a request for a hearing under the statute.
I would dispute that could be considered a request for a hearing because the proposed order hadn't been entered yet, so there's nothing to dispute at that point. It could have been a request for an opt-out to go into circuit court rather than stay in the administrative arena. And the department contacted him to verify whether or not that's what he was asking for.
Well, what's this? What could you direct us to the statutory That's at under 409-2563, the
Yes.
opt-out. Then remind me what subsection that is. Judicial, wait, go ahead.
All right, so
We have,
it's under, wait.
a notice of proceeding in subsection 4.
Oh, it's also interesting because this statute also talks about, well, I kind of got away from what you were asking me.
Yeah, let's go with what I'm asking first, and then we'll go to that.
All right, give me 1 second.
If the parent for whom support is being sought files an extra, okay, so but suffice it to say, since we're having trouble finding it, that one option for a parent is to say, I would rather, and rather than let this proceeding go forward administratively, I'd like to go to court, a judge.
Your Honor, what you're looking for is N3, I guess. It says, if the parent from whom support is being sought submits the requested authorization in subparagraph 1, so that's under N, yeah. That it's the opt-out is a 2-part proceeding, so they would request that it go into circuit court. The department would file a petition in circuit court. He would then, the potential obligor would then have to file a waiver of service.
So in other words, the parent, Mr. Pellegrino, wrote a letter saying, I look forward to appearing before a judge. And you're telling this court, as presumably you did below the department, that there is evidence that the department reached out to Mr. Pellegrino and said, are you asking to appear in a Article 5 circuit court?
Yes.
Yes. And he said, no.
Right.
Right. And he said, I'll wait to see what the proposed order says.
Mm-hmm.
Right. So it's possible for us to infer from that, as the department did, that his letter written on the 30th, the meaning of that letter was clarified by a conversation with the department, who asked whether that letter was a formal request to go before a judge, and that conversation regarding that letter, including a discussion of that letter, included a question from the department about how he wanted to proceed. And he didn't say, I know I want an administrative hearing. He didn't say anything of that sort. He said, I'll wait to see what the proposed order says.
Right. And I'd also point this under 4J, it also says that the request would have to be after the service of the proposed administrative support order for hearing, so that the parent from whom support is being sought does not file a timely request for hearing after service of the proposed support order. The department will issue an administrative support order that incorporates the proposed order.
It seems like the two timeframes that the court is circling around is the first one being a request to go out of the administrative process into the court process.
Right.
And Mr. Pellegrino's letter, to be kind, was ambiguous as to exactly what it was asking for, but maybe it could be interpreted as an insistence on going to the circuit court. However, when there are further proceedings or letters coming from the department, there's nothing from Mr. Pellegrino saying, wait a second, I've asked to go into the circuit court. Why are you still sending me anything? So I mean, that's one thing that honestly is concerning to me. Then the other is when the notice comes out of proposed order in June, then there's not a within 20-day request for a hearing based on what's in the proposed order. And I candidly don't recall if there would be any potential for, after the order is entered, for him to say, wait a second, I was in a medical emergency, I could not act, some sort of relief from, post-order relief. I'm not sure if that's even available, but there is nothing suggesting that request for post-order relief. So
I think he could have done that. Instead, he did not notify. There's no one. Okay, I think if he had filed or notified the department of that quickly, they could have gone ahead and looked at that as a rehearing and vacated the order.
So your
Well,
time has come.
but now, the problem is there's no 1.540 in administrative.
Right. Well,
But
and
now the question becomes, was he denied I'm sorry, Your Honor, go on.
no, I mean, we've come to the end of the time, but I want to ask a question going back to something that was raised earlier. You had said, well, if there's some, I'll paraphrase it. If there's some confusion here, maybe we ought to relinquish jurisdiction and let it get clarified. And I think Judge Atkinson raised the point, do we have the authority or the jurisdiction to do that? Because I am not certain that we do. And so what's the department's position on that? Is there authority for us to relinquish jurisdiction or send it back for further clarification?
At 120.68?
I'm sorry. I
In
didn't hear you.
120.68? Are we under 120.68?
Well, I don't know, but I know I've done this in other appeals throughout the years.
Right. In other words, under the Florida Administrative Procedures Act, is that what you're proposing? In other words, what is that the authority?
No, I'm under the appellate rules. You haven't issued a decision yet, so I'm asking you to relinquish jurisdiction. And
Not in other words, not final relief under 120.68 under the
right.
Which could include remand to the department with instructions. Right. You're saying relinquish jurisdiction pending a final order. So my question would then be, if that's the case, then my question would be, what could or could not occur at the lower tribunal, which is the department, that would change what we could do about somehow granting relief from a final administrative order of the department.
Once jurisdiction is returned to the department, and I discussed the apparent confusion with the language, maybe that my client wants to settle rather than have an order that comes out that starts to put the language in question.
Okay, but under 120.68,
are we under 120.6? I mean, I'm
asking you because this is an appeal. I think I saw that, but we have our ultimate relief can be honestly more flexible than just a straight up an appeal of a final judgment of the circuit court. If it's under 120.68, we have multiple options about what but that's something distinct from relinquishing jurisdiction. That's saying, okay, this appellate case is done, and we're remanding to the lower tribunal, which would be the department, to do X, Y, and Z. So we would have to think about that.
Talking about just coming out with a regular opinion?
Yes.
Okay.
Well, and just to weigh into that, the concern I have from a legal standpoint is we would remand if we find that there's either the fairness of the proceedings or the correctness of the action may have been impaired by a mere material error in procedure and so forth, which I think is the provision Judge Atkinson is looking at. And I think ultimately it becomes the question of interpretation of the notice from the department that preceded Mr. Pellegrino's letter and what he said in that letter, and then the inaction that occurred when the notice of proposed order was subsequently issued. And so this may be an effort to fit the proverbial round peg into a square hole. I'm not sure it fits very neatly. Anything else?
The order.
Is there anything
sorry,
else
Judge.
Nope. Is there anything else from the panel? I've let it go on a bit longer, and I'm fine to let any additional questions get fleshed out because I think it is an important issue. So, Judge Smith.
If Ms. Bernstein wants to, I guess, file a motion for relinquishment for us to consider, then, then maybe that's something we should look at as opposed to you just on the cuff right now. I don't know, but I would be inclined to look at what the motion would state.
And I mean, I could propose, we can talk about this in discussion. I mean, about if there's supplemental briefing on what relief we could grant based on the flexibility of 120.6A. I'm not asking that right now, but I mean, I could ask my colleagues. But the problem right here, Ms. Bernstein, and we're also, speaking to you, Mr. Pellegrino, as we speak, you're listening, obviously. So, I mean, what Judge Silberman brought up, and I don't want to speak for him, is that often our hands are tied. We can't just go on forever trying to reinterpret what happened in the lower tribunal, which is the department. We only have so much authority that's been granted us by statutes in the Constitution. And what the record shows is that on April 26th, there was a letter sent to you, to Mr. Pellegrino, that said, you or the other parent caregiver may file a civil action in an appropriate circuit court at any time to determine your paternity and your support obligations, if any. If within 20 days after you're served with this notice, you file an action in civil court and serve us with a copy of the petition, this administrative proceeding will end and the action will proceed in circuit court. And then in response to that, you sent a letter saying, I look forward to going before, to being with Ms. Lang in front of a judge, which would suggest to the department that you were requesting what that letter informed you was one of your options, which was to go before a judge. And they called you. And according to the logs and according to what the department's saying now, and according to what seems to be in the record, they said, hey, are you asking to go before a judge? And you said no. And you said, instead, I'm going to wait to see what the proposed order is. And then you have additional rights. And in that proposed order, you were informed that you had another choice to make, separate and distinct from the choice in the first letter, in the first notice. And that choice was whether to request an administrative hearing. And you concede now that you did not file a request for an administrative hearing during the time after you received the proposed order. So, we've talked about, we had a robust discussion about what is or is not possible. It just may not be possible for this appellate court, to do anything, whether we relinquish jurisdiction or not, but we can certainly consider that.
If there's nothing else from the panel, Ms. Bernstein, is there anything else you'd like to add before we go back to Mr. Pellegrino?
No, Your Honor.
Very good. Thank you very much. Mr. Pellegrino, you've got about 5 minutes to wrap up. I think you've, to use Judge Atkinson's words, you've heard a robust discussion of these issues. And clearly, we want to try and get to the right result, but we do have constraints on what we can legally do, much as you have certain obligations under the law to comply with the requirements that are posed to you. And there's a question here as to whether you timely complied. So with that sort of laying the groundwork, is there anything else you'd like us to know?
Yes, sir. First, I have to say, I'm in absolute awe of your interpretation of the law. It's absolutely phenomenal. I got some education today, not attending law school. I just knew the difference between what's right and what's wrong. Anyway, like I said, I'm not an attorney, but I was prepared to get in front of a judge at that time before my heart attack, because I did finally receive all the fronts and backs of the 4 checks, which proved that I did pay her, which the Department of Revenue was looking for. Unfortunately, I was not able to present them because what had happened to me. I do have the 4 checks available if the court deems it necessary to take a look at. If not, the only thing I'm asking, and I don't know what remedies this court has to provide me in this particular instance, but please send this case back down to the lower court. Allow me to present all the evidence I have to show that I did truthfully and actually pay that $19,000 as I have stated. And this case will finish up and this FAFSA should be dropped because honestly, I did. And if we want to get to the bottom of the truth, I can prove it with those checks. And also if Stacey Lang is present in the court to answer in front of a judge as well. Other than that, I thank you, Judge Atkinson, Judge Smith, Judge Silberman, for your time, your consideration. This was an unbelievable experience. And I hope I've shown you enough to at least give me the opportunity to present myself and protect my daughter. Thank you, everyone.
Judge Silberman? Judge Silberman?
Yes, Judge.
This is unorthodox, but could I ask a question of the parties?
Yes.
Okay. Because something unorthodox was proposed by one of the parties, and I want to represent to both parties as an individual member of this panel. We have made no decision on whether to relinquish jurisdiction, on whether to affirm or whether to reverse. We've just been having a discussion. But under subsection 6, 409 the statute, it says if the parent from whom support is being sought files a timely request for a hearing, or the department determines that an evidentiary hearing is appropriate, the department shall refer the proceeding to the Division of Administrative Hearings. Now, Ms. Bernstein, do you believe that a failure to request a hearing within 20 days after receiving the proposed order somehow extinguishes the department's right under subsection 6 to itself determine that a hearing is appropriate? I don't know the answer to that.
I don't think that we're under that. I think at this point,
because of the time frame.
The argument that Judge Smith has brought up puts into question a due process issue. And based on that, the department would have authority to still vacate this order. Because although there is no 1.540 in admin, there is case law that talks about how the department, how agencies do have the right to come back and vacate.
Right. In other words, sorry to talk over you, but in other words, what you're saying is you can't now exercise your independent authority as a department to hold a hearing on an order that's already been issued.
Right. We would vacate the order.
Right. So we're under 120.68 or under relinquishment or something like that. That answers my question.
Let me go ahead, Judge. Mr. Pellegrino, I know you had offered to show us the checks. We're not a fact-finding court. We review the law and how the law was applied in the case. So I hope you'll understand that, no, we won't be looking at the individual checks to make a factual determination. But what I will also suggest is the panel will confer, and Mr. Pellegrino, this is for your benefit, just understand, we don't make a decision right here online. We confer at the conclusion of this. Our decision, if any, is rendered. It wouldn't come out for a short period of time, no less than a week or 10 days, which would give Ms. Bernstein the opportunity to take a look at what has been raised today and whether there's something she is able to file on behalf of the department that might assist us in coming to the right decision. The other option for her and for the department is, and for you for that matter, is we can always issue an order for supplemental briefing if we decide that's necessary. So there are things that we as a panel have to talk about. And in the time that we are talking before any decision is rendered, the parties are entitled to file other things that may or may not cause a change. What they don't get to do is provide further argument. But there might be some basis for the department in particular, but you as well, to present something to us that was raised by this argument. Generally, I think at this point, it would probably be from the department because, as you said, you're not a lawyer. You may not have the training to dig into some of this, but I don't want you to feel that this is one-sided either. So both parties have certain opportunities, but we're also bound by what the law lets us do and what jurisdiction and authority we have. So unless there's something else Judge Atkinson or Judge Smith wish to weigh in, or if I've said something that confuses anyone and you want to ask a question, you certainly may. Mr. Pellegrino?
Your Honor, real quick, and I apologize, and then this is my last question or statement. I was a little confused about earlier when Ms. Bernstein and you were talking about the time dates and when something should have been in or not in. I was prepared at the time before my incident to submit all my paperwork, submit the case, the evidence, okay? Unfortunately, I didn't, but if the record shows and they take notice, they did receive my appeal within 14 days after June 30th to show that I was that ready. And that appeal was over 70 pages long. You don't put that together in a week, especially over a 4th of July holiday weekend. I was ready to go. Unfortunately, I didn't hit the cutoff date because of what happened, but I welcome and respectfully ask for the opportunity to present it now that my house is in order. Thank you. Thank you again, Your Honors.
Thank you. And I'm sure if your daughter has spent any time watching, she has seen that you have fought for what you believe is correct. And ultimately, we all want the right decision, but it has to be within the bounds of the law that bind us as well. So
I'm grateful for your time in the hearing.
You're welcome. And Ms.
Thank you, Ms.
Bernstein, Mr.
Bernstein.
Pell, thank you both. That concludes this presentation. We are adjourned. Thank you very much.
Thank you.